Memos is cyber criminal disclosure.
Memos cyber criminal.
Cyber criminal disclosure.
ನಮಸ್ತೆ ನಾನು ರಿಪೋರ್ಟ್ ಒಳಗಡೆ ಇಲ್ಲ ಇದು ಏನು ಬರಲ್ಲ ನಮ್ಮ ಬೇರೆ ಏನು ವಿಶೇಷ ಇದೆಯಾ ಹೌದೌದು ನಮಸ್ತೆ ಇದೆ ಇಲ್ಲಿ ವಾಟ್ಸಪ್ ಸಿಗುತ್ತೆ ವಾಟ್ಸಪ್ನಲ್ಲಿ ವಾಟ್ಸಪ್ನಲ್ಲಿ ಸಿಗುತ್ತೆ ಮಾಮೂಲಿ ರಿಪೋರ್ಟ್ ಒಳಗಡೆ ಸಿಗಲ್ಲ ಮೆಮೊ ಮೂವ್ ಮಾಡ್ತಾ ಇದೆ ವಾಟ್ಸಪ್ ಮಾಡಬೇಕಾ ಹೌದು ಮಾಡ್ತೀನಿ ಇದಾದ್ಮೇಲೆ ಅಲ್ಲಿಗೆ ಹೋಗ್ತಾ ಇದೆ ಇದು ಆದ ತಕ್ಷಣ
ನೋಡಿದ್ರ
ಮೇಡಮ್ 14 ನೀವೇ ಸಾಹೇಬ್ ಹಾಂ
14 ತೊಗೊಳ್ಳಿ ಮೇಡಮ್ ಇದು ಸರ್ ಇದರಿಂದ ಬಂದಿರೋದು ಹಾಂ ಅಪೀಲ್ ಆಗಿರೋದು ಹೌದು ಹೌದು
Two one two three ಇದೆ. Two one two three ಇದೆ. ಇದ್ರದ್ದು edit size ಇದೆ. ಸಾಹೇಬ್ರು ಬಂದ್ಮೇಲೆ.
Any memos?
Bail matter.
Any adjournment? Page 4, serial number 18.
Your Lordship,
Page
cost list one, serial number 18, Your Lordship. The client has been instructed by the counsel on record that he is going to issue NOC, Your Lordship. Kindly a long date may be given. We are going to undertake wakalat, Your Lordship, for the appellants.
ಯಾರು ಹೆಸರು ತಗೊಳ್ಳಿ.
Serial number 18.
So and so submits undertakes to file wakalat for the appellant with the NOC from the earlier counsel on record. Submission is placed on record. List of
Long date may be given. Your Lordship.
Yes.
Serial number
Obliged, Your
19.
Lordship.
Page 5, serial number 19 and 20.
19. I informed the other side. Personal income is
Place time.
right.
Next.
Much.
List 1, page 1,
Sir,
serial number 1, non-compliance of copy subjection for third time. In a sample viramani.
ಒಂದು ವಾರ ಟೈಮ್
Third time it is listed, sir.
a week's time may kindly be granted.
There are several objections, it seems.
ಒಂದು ವಾರ ಫೈನಲಿ ಮೇಡಮ್.
Counsel for the appellant placed for a week's time to comply with all the office objections. This time.
Please.
Next.
Serial number 2, Utsav Gowda.
Lords, in this matter, there is one objection, my lords. That is, the name of the appellant number 2 is not forthcoming with the previous judgments, my lords. However, I filed an affidavit to that extent, and also it is as per my Aadhaar card, which I produced.
No, the appellant is accused number.
Accused number 2, my lords. Appellant number 2.
What is her name?
Her name, my lords, is Munnamma.
Huh.
As per Aadhaar card, my lords, it is Yasmin Banu.
Aadhaar card is Yasmin Banu.
Please, my lords.
You are arraying
In the
one
previous-
person by Munnamma.
Previous two judgments, my lords, that she was arranged as Munnamma.
Is there any document to show that Munnamma is Yasmin Banu?
I filed an affidavit, my lords, on 20th of June.
Twentieth of June, there is no affidavit. Affidavit ಎಲ್ಲಿದೆ?
It's a copy, yeah. Oh, see, don't do this.
June. Passover, Thursday. Passover.
Please, my lords.
Serial number 3.
For appellant, my lords. My lords, the same appellant during crime stage had filed appeal before this court, my lords, at 3.1.
Hmm.
After filing memo of withdrawal, we approached the trial court again. Thereafter, my lords, after rejection, we've come here. My lords, 3.1 needs to be withdrawn. Counsel on record is also present.
Who is for the
In the
appellant
last
in
date of
3.1?
hearing, we had filed the memo for withdrawal.
Withdrawal. Idea. Counsel for the appellant filed a memo seeking permission to withdraw the appeal. Memo is placed on record. Appeal is dismissed as withdrawn.
3 next week, my lords. Serial number 3 may be taken up next week.
Letter received from Deputy Superintendent. You know what is the letter? Okay, ಅದು ಅವ್ರ ಗಮನಕ್ಕೆ ಬಂದಿದೆ ನೋಡಿ. Yes, have you taken note of the letter from the Superintendent of Police?
No, my
Nodi, you go through that.
Please.
Yes, when?
Next week, my lords.
Trace for time. Counsel, 3 ನಲ್ಲಿ counsel for the appellant trace for time. Yes.
Great.
Dismiss ಆಗುತ್ತಲ್ಲ, dealing in view of dismissal of such. Next.
Serial number 4.
Your Lordship, I am for the appellant, Your Lordship. I have taken steps for R2, Your Lordship.
Case report,
Verifying, my lord, kindly pass over.
pass over.
Serial number 5. Highest up. Highest up.
ಹಾ. ನೋಡಿ ಕೊಡಿ ಕೊಡಿ ಕೊಡಿ. Counsel for the appellant is again absent. No, there is no representation. Order sheet dated 6/12/2024 reads as under. It is noticed that as per the office note, it is noticed that the appellant is in custody since more than 6 years. But the learned counsel for the appellant is not appearing before the court. Hence, so and so amicus curiae is appointed. So and so is appointed as amicus curiae to assist the court in disposal of the appeal on merits. ಅದಕ್ಕಿಂತ ಮೊದಲು not appearing. IA1 of 2021 is pending consideration. I do not find it is noticed that the appellant was in custody even during trial. Hence, IA1 of 2021 is dismissed. So and so is appointed as amicus curiae to assist the court in disposal of the appeal on merits. Office is directed to communicate this order to the amicus curiae and furnish copies of so and so. Learned amicus curiae and learned SCGP are directed to SCGP, no additional SP, are directed to address their arguments on the next date of hearing without fail, since the appellant is in judicial custody. Dismissed.
Serial number 6. MR Manjunath.
Regarding maintainability melodies, 498 she filed a seeking transfer the investigation. Now she is filed complaint to be a Bangalore melody. The IOS sent the as per the matrimonial is in Asan melody. Now investigation is going in Asan. She is seeking transfer the investigation here only. Now is residing with her child here only. Honorable Apex.
Can it be done? Offense was committed in Hassan jurisdiction.
No, man, your year also committed melody. They are also committed.
But FIR was registered in Hassan.
No. FIR initially registered here only, Milad. Later they have transferred the set to Assam.
Why?
Investigation is matrimonial is Assam.
So at your request, it was transferred.
Please, ma'am. They have requested.
Who?
Accused.
You are for the
They, as per
complainant.
their statement, after marriage he resided in Assam. So the IOS transferred the FIR to Assam. New FIR has been registered.
Notice agida.
ಇಲ್ಲ.
SGP take notice for response. Number 1 and 2. ಏನಿದು ಮೇಂಟೈನಬಿಲಿಟಿ ಇದೆಯಲ್ಲ?
Maintainability, other objections make, I will comply, my lord.
What is this objection regarding maintainability?
Objection, my lord, jurisdiction, trial.
ಅದೇ ನೋಡಿ, you take notice and make your submissions.
Yes.
ಅವ್ರಿಗೆ ಅಷ್ಟೇ R1 ಗೆ HCGP takes notice for respondent number 1. Counsel for the petitioner and learned HCGP pray for time to address their arguments on maintainability.
Yes.
Yes.
Hearing वाला ये serial number 7 जगदीश MS.
ಕೊಡಿ. Counsel for the appellant is absent, no representation. It is noticed that the office objection is already complied. IA 1 of 2025 is filed seeking condonation of delay in preferring the appeal. ಏನು reason and condonation. It is stated that the appellant is in custody and he could not prefer an appeal in time. Reasons stated in the memorandum of facts accompanying the application, IA 1 of 2025 is accepted. Accordingly, IA 1 of 2025 is allowed. Delay of 63 days in deferring the appeal is condoned. Call for trial court records.
Serial number 7. Serial number 7.
HCGP takes notice of Yes, next.
Serial number 8 Mahesh Arupin.
Right. The only case of a prosecution that Lord accused Lord to promise to marry the deceased and not married Lord. Because of that, she committed offense.
HCGP take notice for respondent. Private idara.
Not private illa. Idu bail is rejected by the trial court. Lord.
Yes. When will you argue?
Please, Lord.
When will you argue?
But today itself I am ready,
Yes.
Lord. It is covered by judgment of Supreme
Yes.
Court. You last time kindly see, Lord, the FIR, the complaint, Lord, is at page number.
No. Who is the accused? He is the sole accused.
Sole accused, Lord.
When he was arrested?
He was arrested, Lord, on 2/5.
25.
4/5, 4/5, Lord.
This year.
Sorry, 14/5, Lord. Sorry, Lord. 14/5.
What are the offense?
Please, Lord.
Offense.
Offenses, Lord, is section 3(1) R and S and V, Lord, of SC/ST Act and section 108 of BNS Act.
What is 108?
108, Lord, abatement to commit suicide. Lord.
306 adu.
Yes, Lord, 306 in there.
How she committed suicide? Whether she has committed suicide?
She committed suicide
How?
by hang, Lord, in her house, Lord, in bedroom. The case of the prosecution is only this, Lord. She was working at Bangalore. The accused was also working at Bangalore. According to her, Lord, she was in love with this boy, Lord.
Yes.
After some time, Lord, he said to her that, Lord, since she belongs to different caste,
Yes.
he is not going to marry her.
What
This
is
is
the
the
age?
only thing.
Age of the deceased?
Age of the deceased is, Lord, 27. Lord. Anjali,
27.
25 in the.
25.
Yes, Lord.
Yes, what do you say?
And in addition to that, I have filed writ petition. There is a stay of investigation, Lord. It is pending.
Because of the verbal
I
exchange.
think he was apprehended on 14/5.
Yes, ma'am. Because of the.
Subject to conditions.
Yes, ma'am.
Yes. So the appellant being the sole accused in so and so is seeking grant of bail so and so. Heard so and so have used affirmative for the following reasons. The appellant is alleged as accused in so and so. for the offense punishable under section so and so. He was apprehended on 14/5/2025. Since then, he is in judicial custody. Is the specific contention of the prosecution that the deceased was aged 25 years, was in love with the appellant, and since she was belonging to scheduled caste, the appellant refused to marry her and abetted her to commit suicide, as a result of which she committed suicide by hanging in her house. Since the accused was apprehended on 14/5/2025, it is not the contention of the prosecution that the appellant is required for further investigation. It is also not the contention of the prosecution that he is having any criminal antecedents. Reasonable conditions may be allowed subject to conditions.
Please.
ಅಯ್ಯೇ ಇದ್ರೆ ನೀವು ಆಫೀಸರ್ ಅಯ್ಯೇ ಫಸ್ಟಿಗೆ ಅಲೋ ಮಾಡಬೇಕು ಅಯ್ಯೇ ಒನ್ ಆರ್ಡರ್ ಶೀಟ್ನಲ್ಲಿ ಮಾಡಿ ಅಯ್ಯೇ 1/2023 dispensation from producing certificate copy of the order dated 24 for the reason stated in so and so year.
Serial number 9, Parmeshwaran Hegde, yes, sir.
Yes, what is this IA?
Let's application filed by the wife of the appellant for in the custody of the 4 documents. It's a case of the disproportionate asset in the trial court.
Which are the documents you want?
Lordship may kindly see the page number 2 of my application. These are the sale deeds and my mother deed of the sale deed. Serial number 1 is the gift deed, serial number 2 is the sale deed, serial number 3 sale deed, serial number 4 sale deed. All these documents were seized when our house was subjected to raid. Subsequently, post investigation, charge sheet has been filed against my husband.
I understood that.
I have been
proportionate.
Yes, I have been convicted. Conviction ad nantaram, while imposing the sentence of fine, the trial court has categorically said in lieu of attaching the property, I am imposing the fine.
What was the fine amount?
So 19 lakhs and odd 19 lakhs. Totally, the fine amount is 19 lakhs.
But it is not yet paid.
That entire amount has been paid.
Fine amount.
Entire fine amount has been paid. And now my husband is he has been dismissed from the service. He has attained superannuation. Then because of the conviction, his pensions, everything has been withheld. Now we have no. So
he has not preferred any appeal.
Appeal is pending. This is the appeal.
This is the appeal.
This is the appeal. And in fact, earlier he had filed an application on behalf of wife. The husband appellant himself has filed an application, but this court was of the opinion that no, it has to be filed by the property owner. Hence, I filed this. That application was withdrawn, and now the wife has filed the application before this.
What is the objection? No objection.
No, I'll oppose you.
On
But
what ground?
trial court has observed that for the enhancement of sentence, we are not yet filed any appeal as against that order. But the trial court observed that instead of confiscation, it's a fine amount imposed.
You are not aggrieved by that.
And independent appeal is not there.
That means to say you are not aggrieved by that.
That's
the scope of the appeal is only to find out whether conviction is to be sustained or not.
Yes. If they deposit the entire fine amount.
Fine amount deposited.
Entire amount has been deposited. How receipt to produce?
Third learned counsel to the appellant and the appellant is also the advocate for the applicant in IA 1/2025, seeking release of the documents, and the learned counsel for respondent. IA 1/2025 is filed by the applicant, who is the wife of the appellant, seeking to return the original documents mentioned in the applications, that is the gift deed and sale deeds, which were seized by the investigating officer during search conducted in the house of the accused and the applicant. It is stated that the appellant was convicted by the trial court, and while so convicting, imposed a fine of rupees 19 lakh.
19,83,319.
19 lakh 83,000
319.
319 in lieu of confiscation of
In lieu of confiscation of the properties.
properties seized in the matter. It is also stated that the appellant has already deposited the entire
On
fine
2/2/22.
on 2/2/2022. All these facts are not in dispute. ಅದಕ್ಕಿಂತ ಮೊದಲು ಇನ್ನೊಂದಾಗಿ respondent has not challenged the quantum of sentence or imposition of only fine on the accused in lieu of confiscation of the property. ಅದಾದ್ಮೇಲೆ all these facts are not in dispute. Under such circumstances, I do not find any reason to deny the relief claimed by the applicant to return the original gift deed and 3 sale deeds mentioned in the application, which were admittedly seized during search conducted in the house of the accused and the applicant. Hence, I allow the IA1 office is directed to, that is in trial court records.
Well, it's in the trial court records.
Trial court.
It has been already secured. It is available before this.
It is noticed that the documents referred to in IA1 of 2025 are found in the trial court records. Office is directed to return those documents and to the learned counsel for the applicant on, yes,
Have to produce
by
a certificate copy.
substituting the same with copies.
Please, ma'am.
Yes. ಈಗ ಟ್ರಯಲ್ ಕೋರ್ಟಿಗೆ ಹೋಗ್ಬೇಕಾ ಅಂದು ಹೌದು ಟ್ರಯಲ್ ಕೋರ್ಟ್ ರೆಕಾರ್ಡ್ ನಮಗೆ ಬಂದಿದಲ್ವಾ ಇಲ್ಲೇ ಕೊಡ್ಬೋದಲ್ಲ ಇಲ್ಲೇ ಕೊಡ್ಲಿಕ್ಕೆ ಹೇಳಿ ಇಲ್ಲೇ ಕೊಡ್ತಾರೆ ಇಲ್ಲೇ ಕೊಡಿ ಮತ್ತೆ ಕಳ್ಸೋದು ಮತ್ತೆ ಬೇಡ
Serial number 10, KBK Swami.
For appellant in this case, my lord, pending grant 2 weeks time to file paper book, my lord. We have filed a application for stay the judgment of the trial court, my lord. But at this juncture, we are not pressing that IA. We will address our argument on May. Even earlier application also allowed.
2 of 2023 filed for seeking stay of the impugned judgment of conviction and order of sentence is not pressed. Submission is placed on record. IA 2 of 2023 is dismissed. Counsel for the appellant placed for time 2 weeks time to file the paper book. List after 4 weeks.
That IA may be disposed of, my lord, sir.
Disposed of.
Yes, my lord.
You file paper book.
Post the matter for final hearing, my lord.
Yes.
Even earlier.
Admit agida.
Yes, my lord. Earlier hearing application is also been allowed, my lord.
For final hearing after filing the paper book. I paper book file ಮಾಡಿ.
Yes, ma'am.
Next.
Serial number 11, Viranna Tigdi.
I make a submission, my lord. I appeared recently ಇದರಲ್ಲಿ victim ಅನ್ನ ಇದನ್ನ ಪಾರ್ಟಿ ಮಾಡಬೇಕಾಗುತ್ತೆ
ಇಲ್ಲ.
ಮಾಡಿಲ್ಲ ಮಾಡ್ದಂಗೆ ಕಾಣಲಿಲ್ಲ ಸರ್. I appeared recently.
Counsel for the appellant prays for time on the ground that the victim is not arrayed as a party in the appeal.
Am I permitted to implead her as respondent number 2?
File the application.
Pardon?
File the application.
Please.
Please file the application. ಯಾರು ಏನು ಅನ್ನೋದು ಗೊತ್ತಿರಲ್ಲ. Better.
ಅಲ್ಲ PW4 ಅದೇ ಮಾಡ್ತಾರೆ. PW4 is the victim ಅಷ್ಟೇ.
ಮಾಡಿ. Yes, next.
Final hearing, serial number 12, Rahul P. Patil.
Is this in custody?
No, my lord.
Custody.
No, my lord.
No.
My earlier application was allowed, my lord. On that date was given.
ಅಲ್ಲ ಮತ್ತೆ ಇದು ಯಾಕೆ 2022 ಯಾಕೆ ಬಂತು ಫಸ್ಟ್ ಗೆ?
But he is dismissed from services. Sir.
What was the urgency?
He was dismissed from the services, my lords. For past 2 years, he didn't have work. On that ground, I had moved an application for early hearing.
Yes.
But the appellant has been convicted for my lords, provisions under section 13(1)(d) and 13(2), my lords, for sentence of 4 years and fine of 4 lakhs, my lords.
He's the sole accused.
Please. Sole accused.
Sole accused.
13(1)(d), 13(2).
Please.
Hmm.
Punishment is, my lords, for 4 years and 4 lakhs fine. Let's brief facts of the case, sir, my lords. The appellant was working as assistant director of factories at Mangalore, my lords. On 31/2016, my lords, PW1, who was a stranger, lodges a complaint with the prosecution. On that complaint, a complaint has been registered, crime has been registered, my lords. Thereafter, charge sheet was filed. That's for prosecution has examined, my lords, 11 witnesses and marked 48 documents. On defense side, my lords, 6 witnesses have been examined. Lordship may kindly come to exhibit P1.
ಫಸ್ಟ್ ಡಿಟೇಲ್ ಆಗೋ ಫ್ಯಾಕ್ಟ್ಸ್ ಹೇಳ್ಬೇಕು, ಆಮೇಲೆ
Please.
ದಟ್ ಕಮ್ ಟು ದಿಸ್ ಅದೆಲ್ಲ
My
ಆಮೇಲೆ.
lords, after the lodging of the complaint, my lords, on the same day, my lords, the prosecution had raided the office of the appellant. Wherein, my lords, this is a case of raid, my lords, not trap. My lords, around 5:15 p.m., my lords, along with 2 witnesses and the complainant, the IO had raided the office of the appellant. At that time, my lords, while the appellant was getting out of the office, he was stopped and raid was conducted. A search was also conducted, my lords. During that search, my lords, a cash of rupees 1,12,865 rupees was seized, along with 1 silver coin.
1,12,000.
865 rupees. That is on 30/11/2016.
When date?
Yes?
Date of raid?
30/11/2016. Same day when the crime was registered. Thereafter, my lords, on the same day.
After registering the FIR, raid was held.
Please. Thereafter, my lords, on the same day, my lords, even the house was raided. In that raid, my lords, an amount of rupees 2,36,650 rupees was recovered.
Yes.
Thereafter, my lords, charge sheet was filed. Prosecution has examined 11 witnesses, my lords.
ಅದೆಲ್ಲ next.
PW1 is the complainant. The lordship may kindly take the exhibit P1 complaint, my lords. It is at page 297. Exhibit P1, my lords, page 297, that is the complaint. Complainant is the stranger, my lords. He has no work before the appellant.
Yes.
I'll read the complaint, my lords.
Hmm.
ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ತಮ್ಮಲ್ಲಿ ಕೇಳಿಕೊಳ್ಳುವುದೇನೆಂದರೆ, ನಾನು ಸಾಮಾಜಿಕ ಕಾರ್ಯಕರ್ತನಾಗಿದ್ದು ನನಗೆ ನನ್ನ ಆತ್ಮೀಯ ಒಬ್ಬರಿಂದ ಮಂಗಳೂರು ಕಾರ್ಖಾನೆಗಳ ಸಹಾಯಕ ನಿರ್ದೇಶಕರು ಆಗಿರುವ ಶ್ರೀ ಎಚ್ ಸುರೇಶ್ ಎಂಬುವವರ ಕಾರ್ಖಾನೆಗಳ ಪರವಾನಗಿ ನವೀಕರಣ ನಿರೀಕ್ಷಣೆ ಪತ್ರ ನೀಡುವುದು ಮುಂತಾದ ಸರ್ಕಾರಿ ಕೆಲಸಗಳನ್ನು ನಿರ್ವಹಿಸಲು ಕಾರ್ಖಾನೆಗಳ ಮಾಲೀಕರಿಂದ ತಮ್ಮ ಅಧಿಕಾರವನ್ನು ದುರುಪಯೋಗಪಡಿಸಿಕೊಂಡು ಹಣ ವಸೂಲಿ ಮಾಡುತ್ತಿರುವ ಬಗ್ಗೆ ದೂರು ಬಂದಿರುತ್ತದೆ. He gets someone tells him that the appellant is demanding money. Yes. Thereafter, ಈ ದಿನ ದಕ್ಷಿಣ ಕನ್ನಡ ಜಿಲ್ಲೆಯ ಶ್ರೀ ಎಚ್ ಸುರೇಶ್ ರವರಿಗೆ ಬೆಂಗಳೂರು ವರ್ಗಾವಣೆಯಾಗಿ ಹೊಸ ಸಹಾಯಕ ನಿರ್ದೇಶಕರು ಅಧಿಕಾರ ವಹಿಸಿಕೊಳ್ಳುತ್ತಾರೆ. ಇವತ್ತು ಬೆಳಗ್ಗೆಯಿಂದ ಸದರಿ ಅಧಿಕಾರಿ ಬೇರೆ ಬೇರೆ ಕಾರ್ಖಾನೆ ಮಾಲೀಕರಿಗೆ ಹಾಗೂ ಸಂಬಂಧಪಟ್ಟವರು, ಮ್ಯಾನೇಜರ್ ಮುಂತಾದವರಿಗೆ ಕರೆ ಮಾಡಿ ರೂಪಾಯಿ 30,000ದಿಂದ 50,000ಕ್ಕೂ ಮೇಲುಪಟ್ಟು ನೀಡುವಂತೆ ತಿಳಿಸಿ ಹಣ ಸಂಗ್ರಹಿಸಿ ಕಡತಗಳಿಗೆ ಸಹಿ ಮಾಡಿರುತ್ತಾರೆ. ಇವರ ಕಚೇರಿ ಮೇಲೆ ದಾಳಿ ನಡೆಸಿದಲ್ಲಿ ಅಕ್ರಮವಾಗಿ ಸಂಗ್ರಹಿಸಿರುವ ಹಣ ಪತ್ತೆಯಾಗಿರುವುದು. The complaint is hearsay, my lords. And he says, my lords, the appellant was calling the other managers and owners and was demanding money. ಆದ್ದರಿಂದ ತಾವುಗಳು ಕಾನೂನು ಕ್ರಮ ಕೈಗೊಂಡು ತಮ್ಮ ಅಧಿಕಾರವನ್ನು ದುರುಪಯೋಗ ಪಡಿಸಿಕೊಂಡು ಕಾರ್ಖಾನೆಗಳ ಮಾಲೀಕರಿಂದ ಹಣ ಸಂಗ್ರಹಿಸುತ್ತಿರುವ ಶ್ರೀ ಎಚ್ ಸುರೇಶ್ ಅವರ ಮೇಲೆ ಕ್ರಮ ಕೈಗೊಳ್ಳುವುದಾಗಿ ಕೇಳಿರುತ್ತೇನೆ.
Who is PW1?
PW1 is the complainant, my lords.
PW2?
PW2, my lords, is the witness when the raid was conducted. 3 is one of the...
Mazar of the exhibit P.
Mazar is exhibit P for 30.
Yes, also ಹೇಳಿ exhibit PW ಹೇಳಿ.
Please, my lords.
Mazar.
P exhibit P3, my lords.
P3, my lords.
Mazar witness to exhibit.
Please, my lords. Exhibit
P3.
P2, my lords.
PW3.
PW3, my lords, is one of the
Employee, my
worker,
lords. One of the employee of the private.
worker in one of the factories. Is an accountant apparently.
What he speaks?
My lords, he deposes that there is a demand and acceptance.
Then
PW4, 5, 6 are all different factories, my lords. They are employees at different levels who have consistently deposed that this gentleman had called them and asked for money. PW7, my lords, is the sanctioning authority. No, my lords, he's the one who has prepared the map in the crime scene or the raiding party. During the raid, he has assisted in preparing the map.
PWD employee.
PW7.
No, he is an employee under PWD.
No, he PWD. Yes, he is not an employee of a factory. He is under PWD.
Sketch is marked as exhibit.
P3.
I'll check and ascertain.
P3. Exhibit P3.
PW8, my lords, is one of again an employee in the factory, but he has deposed otherwise, my lords. He's been declared as hostile as well.
Then PW9.
PW9 also is another employee of a coconut oil factory.
Owner of a private.
Owner employee. And PW10, my lords, is the sanctioning authority. And PW11 is the investigating officer.
Sanction order exhibit.
My lords,
P27 minutes.
though there is a main issue raised is as regards the competency of the, at least in terms of the pleading,
27.
it's a competence of the sanctioning authority.
Exhibit.
P27.
Who is PW10? What is his designation?
Deputy Director.
My lords, the designation is, he is the Assistant Executive at Labor Department. ಪೂರ ಬರೋದಿಲ್ಲ ನೀವು ಅಸಿಸ್ಟೆಂಟ್ ಎಕ್ಸಿಕ್ಯೂಟಿವ್ ಏನಾದರೂ ಬೇರೆ ಇರುತ್ತೆ. ವಾಟ್ ಕೈಂಡ್ ಆಫ್ ನಾನ್ಸೆನ್ಸ್ ಇಸ್ ದಿಸ್ ಪ್ರಕಾಶ್?
These employees of private factory, they demand, they speak only about demand or acceptance also? All the witnesses.
We could find out.
No, except PW8, all others have supported.
PW1 and 2 are not relevant. Because one is the complainant who is not concerned to any of this. He is complains himself to be a right minded.
Yes.
Right spirited citizen. PW2 is a smarter witness. Was there 3, 4, 5, 6
And 9.
and 9. And 11 IO also is there. So is also. And there is the relevance in terms of DW1, DW2, DW3, DW4. They are all relatives numbers.
Who are,
1, 2, 3 are relatives of appellant accused.
Incidentally, this whole episode happened during the demonetization numbers. And there were the new 2,000 rupees notes which were seized from him in a certain quantum. And he has not shown the 131 statement, he has not made any claim as regards to defense as such.
no,
But-
what these relatives speak.
Relatives say that they have given,
on the amount.
but my lords, the impugned order tallies the entire number of notes seized and they have given, it does not match. There are extra about 25 notes. I can give the numbers, my lords.
26.
Huh. Some 26 extra notes are left out. And other than that, my lords, there are other currency also for which there is no explanation. So it's not that entire note was only in 2000.
According to DWs 1, 2, 3, why they have given the cash?
My lords, apparently for renewing of the licenses.
No, DW 1, 2, 3.
My lords,
What is
there
the
is no explanation. They are relatives and there was some,
They have given
no,
the
there is
No,
some
my lords.
surgery
There
or
is
some.
the appellant's wife was pregnant, my lords. She delivered a baby on 19/11/2026. And he was shifting, my lords, as the transfer order was ordered to him, my lords, for shifting as well as for the medical expenses that paid, my lords. DW1 is the brother-in-law, 2 is the brother, 3 is the sister of the appellant.
4 is the owner of the house.
Which he was residing in Mangalore.
And 5 is the transport.
DW 1 is the brother-in-law.
Brother-in-law,
2 is brother.
brother, 3 is sister,
Hmm.
4 is the landlord of the house which the appellant was residing in Mangalore. DW5 is the packers and movers, my lords, which he wanted to transport the.
ಅವ್ರದ್ದೇನಂತೆ?
He had booked, my lords, which they had agreed for a amount of rupees 25,000.
How it is relevant?
Well, I had obtained money to clear all those debts, my lords, to pay the transport, rent, and DW6 is my friend.
What he says?
He says he had paid 20,000, my lords,
Okay, everybody has paid.
on my demand. And thereafter, my lords, during the period, my lords, 1/9/2016 to 15/10/2016, I have withdrawn an amount of rupees 3,90,000 from the bank.
Amount found in our office and ಎಷ್ಟು? 3
Office is 1 lakh.
Total the loss is 3,49,550.
3 lakh.
49,550.
Both office and
Both office and
office ನಲ್ಲಿ ಎಷ್ಟು?
Only office is
12,000.
1,12,865.
House?
House 2,36,650. Total is 3,49,550. In this amount, around 110 2,000 rupees notes are seized. That totals to 2,20,000 rupees. Let's start in other various denominations. Exhibit P3 is search Panchnama, my lords, and exhibit P.
Yes.
Let's, may take your lordship to cross-examination of PW1, my lords.
ಏನಿದೆ ಈಗ? What is there to
PW1 has
support
had no business with me, my lords, or in my
it?
office.
No bar, sir.
No, my
He
lords.
has collected some information and he informed that.
Please,
What
please.
is wrong in it?
There's nothing wrong, my lords.
Leave it then.
Please.
Don't comment on that.
Well, that's only one, as I read out in the complaint, my lords. The statement is that I had called certain people and obtained, my lords. My phone was seized.
Yes.
No call details have been recorded.
Yes, but you have to explain the cash which was found in your possession. You are a public servant.
Please,
The
please.
burden is on you.
Please, my lords.
Yes.
My lords, for that, my lords, the defendant witnesses have been examined.
Adan prove ಮಾಡಿ.
Please, please. my
You
lords.
admit that the burden is on you, not on the prosecution.
Please, my lords, I admit that the amount was with me.
Yes.
My lords, your lordship may kindly see defense witness, my lords. Lords, DW1, my brother-in-law has paid me an amount of rupees 56,000.
DW,
One,
how much?
56,000, that is 2,000 notes of 28 notes.
Then
DW2, my lords, has paid 52,000 to a tune of 26 notes.
2000.
Please, please.
26 notes.
26 notes. And DW3 is my lords, my sister, has paid 40,000, 20 notes. DW6, my lords, my friend, has paid 20,000, 10 notes. In total, it amounts to, my lords, 1,68,000.
1 lakh.
68,000. That's during the period 1/9/2016 to 15/10/2016, my lords, as per Exhibit P25. 1/9/2016 to 15/10/2016. That is as per Exhibit P25. I have withdrawn an amount of rupees 3,90,000 from my account.
How much?
3,90,000.
That is for your expenses.
Look, I had even 3,90,000 and these amounts which I had, my lords. In that expenditure, after expenditure, I had, this amount was remained with me.
What is the amount?
That is 1,68,000, 3,29,000. So 49,000
No, sir. You have withdrawn 3,90,000.
from my account.
Yes.
Thereafter, I had obtained the amount from my sister, brother-in-law, and brother.
The 1,68,000.
Please, my lords. I had this much of amount from starting of.
So you have not spent any amount during.
I have spent, my lords, because 3,90,000 plus 1,68,000. I have spent around 1,60,000. 1 lakh, around 2 lakhs, my lord.
Why you have not stepped into the witness box? You could have easily explained.
Please.
What made you to remain outside? Guiltiness.
Like trial, I cannot talk about it.
Guilty
my
mind.
lords. No, my lords. My lords, what has happened is, my lord, there is no.
See, instead of all these exercise, you could have straight away entered into witness box to say, yes, I have received this amount.
Please.
You would have faced the cross examination.
Once I had obtained that amount for my medical thing that my wife was pregnant.
ಇದರಲ್ಲಿ ಏನು ಡಿಕ್ಲರೇಷನ್ ಅದೇನು ಇಲ್ವಾ? ಅಮೌಂಟ್ ಡಿಕ್ಲರೇಷನ್ ಏನು?
There was no register in the office as well as at home.
No register is maintained.
No, specific contention that the registry is
Not maintained. That is compulsory.
Yes, it is compulsory also is noted in the review note. Not to mention, my lord, in the 313 statement, there is no whisper of this entire story.
Yes, as per Exhibit P4, I have given my lord's written statement that I had withdrawn an amount of which 3,90,000.
No, what is your explanation regarding register? It is mandatory in all the government office.
Please, my lords.
Why it was not applicable to you?
It was not maintained, my lords.
ಇನ್ನು 313 ನಲ್ಲಿ ಏನ್ ಹೇಳಿದ್ದಾರೆ?
Exhibit P4 is, my lords, my written explanation.
1 minute, I'll come to that. Exhibit
P4, my lords. It's at page 308.
that is on the date of raid.
No, my lords, this was on later stage, my lords. This was on 23/2016. No, my lords, this was a letter to explanation to letter dated 23/2017. The notice issued by the police.
30/11/2016.
Was the incident, date of incident.
No, on the date, same date you have given it. Earliest explanation.
Let's
Read that.
page at 309.
Exhibit P4. Exhibit P4.
P4 starts from next page, 309.
Next page ಬೇಡ ನನಗೆ. Exhibit P4 is
I'm in paper book.
now I am looking at the original documents. It is addressed to Police Inspector Bhrashtachara Nigraha Dala, Dakshina Kannada Jille,
Please,
Mangaluru.
my lords. ವಿಷಯ ದಿನಾಂಕ 23/2017 ನನಗೆ ನೀಡಲಾದ ಪೊಲೀಸ್ ನೋಟಿಸ್.
ಅದೆಲ್ಲ ಇಲ್ಲ ಇಲ್ಲಿ. 1 minute. ಇದು ಕೊಡಿ ಅವ್ರಿಗೆ. ಇದು ಕೊಡಿ ಅವ್ರಿಗೆ. That is exhibit P4.
Yes, my lords. In this he has stated, my lords, two friends had given a sum of rupees 1 lakh. They have not been examined.
Read it.
ನಾನು
ಕೊಡಿ ಇಲ್ಲಿ, ನಾವು ಓದ್ತೇನೆ.
ದಿನಾಂಕ 30/11/2014 ನನ್ನ ಕಚೇರಿ ಮತ್ತು ಬಾಡಿಗೆ ಮನೆ ತಪಾಸಣೆಗಳಿಗೆ ರೂಪಾಯಿ 2,000 ಮುಖ ಬೆಲೆಯ 110 ನೋಟುಗಳನ್ನು ಇಲ್ಲಿವರೆಗೂ ನಾನು ಮಂಗಳೂರಿಗೆ ಶ್ರೀ ದಿವಾಕರ್ ಅವರಿಂದ ಸುಮಾರು 42,000, ಶ್ರೀ ಎನ್ ಚಂದ್ರಶೇಖರ್ ಅವರಿಂದ ಬೆಂಗಳೂರು ಸುಮಾರು ರೂಪಾಯಿ 52,000, ಶ್ರೀ ನಂದಕುಮಾರ್ ಬೆಂಗಳೂರು ಅವರಿಂದ ಸುಮಾರು 56,000, ಶ್ರೀಮತಿ ಎಚ್ ಮಂಜುಳಾ ಅವರಿಂದ ಸುಮಾರು 90,000 ಮತ್ತು ಶ್ರೀ ಆರ್ ರಾಜಶೇಖರ್ ಅವರಿಂದ ಸುಮಾರು 20,000 ನಾನು ATMಗಳಿಂದ ಡ್ರಾ ಮಾಡಿದ್ದು ನನ್ನದೇ ಹಳೆ 500 ಮತ್ತು 1,000 ಮುಖ ಬೆಲೆಯ ನೋಟುಗಳನ್ನು
ಅದು ಎಲ್ಲಿದೆ ರೀ? ಎಲ್ಲಿ ಓದ್ತಾ ಇದ್ದೀರಿ?
ಅಲ್ಲ, ಅದು ಬೇರೆ ಇದೆ.
311 of the paper.
ಕೊಡಿ ಇಲ್ಲಿ ಅವರಿಗೆ ತೋರಿಸಿ. ಡೀಟೇಲ್ಸ್ ಎಲ್ಲಿದೆ? Exhibit P4.
Please.
ನೋಡಿ ಅದು ಎಲ್ಲಿ ನೋಡಿ ಅದು Is it not the explanation?
This was on the day of raid, my lords.
That assumes importance. ಅದೇನದು explanation ಅಲ್ವಾ? That is what, you please read that exhibit P4.
ನಾನು 2000 ರಿಲೇಷನ್ ಆಗಿದ್ದು ನಮಗೆ ಬೆಂಗಳೂರಿಗೆ ವರ್ಗಾವಣೆ ಆಗುತ್ತದೆ. ನನ್ನ ಕಚೇರಿಯಿಂದ ಮತ್ತು ನಿವೇಶನದಲ್ಲಿ ನನಗೆ ಸ್ನೇಹಿತರು ಪ್ರಮೋಷನಲ್ ರಾಜೇಶ್ ಅವರುಗಳಿಂದ
No, what are the names stated there? Promotional Rajesh.
There are only two names coming here.
How much? 1 lakh.
1 lakh.
Idu exhibit P4. Which is the explanation you are referring? Both of you are referring.
As per paper book, it is exhibit P4.
Paper book alla adu ಏನು exhibit ಏನಾರ ಬೇಕಲ್ಲ ಎಲ್ಲಿ ಯಾವಾಗ ಕೊಟ್ಟಿ
P4 ಅಂತಾನೆ exhibit paper book ಅಲ್ಲಿ ಇದೆ. ಅವರು ಕೊಟ್ಟಿರೋ paper book.
ಇಲ್ಲ ಒರಿಜಿನಲ್ ಅದಕ್ಕೆ ತೋರಿಸ್ತಾ ಇದ್ದೀನಲ್ಲ.
There is not to mention lot of in the change in Kannada words. I took out the original from the
See, that is why I never look into the paper book. Only original records, no paper book. That will reduce the burden of comparing the paper book with the original.
No, this is serious anomaly.
Yes. That is why I gave it to you, both of you.
Look, that document can be found at exhibit P6. P6.
The one my notes are referring to is at P6.
P4, sir.
No, in the paper book it is P6. There's only one letter kind of thing that 1 lakh rupees system.
Dated.
Please go one document before and my notes can find it.
No, P4 is with regard to the amount found in his office. P6 is with regard to the amount found in his house.
I think that's
Please,
an interpolation.
Interpolation alla court ಹೇಳೋದೆ P6 ಅಂತ.
Paper book ಅಲ್ಲಿ interpolation.
ಅದು ಗೊತ್ತಿಲ್ಲ. I am not bound by that.
Please, my lords, P6. May I read, my lords? That is dated 36/2016.
Which one?
Which your lordship was referring as P4.
P4 already it was read. ಮಂಗಳೂರು ವಿಭಾಗ ಎರಡನೇ ವಿಭಾಗದಲ್ಲಿ
ಕೆಲಸ ನಿರ್ವಹಿಸುತ್ತಿದ್ದು ನನಗೆ ಸದ್ಯದಲ್ಲಿ ಬೆಂಗಳೂರಿಗೆ ವರ್ಗಾವಣೆವಾಗಿರುತ್ತದೆ. ನಾನು ಕಚೇರಿಯಲ್ಲಿ ಕೆಲಸ ನಿರ್ವಹಿಸುತ್ತಿದ್ದೆ. ದಿನಾಂಕ 30/11/2016 ನನಗೆ ಸ್ನೇಹಿತರಾದ ಪ್ರಮೋಷನಲ್ ರಾಜೇಶ್ ರವರುಗಳು ಹಣ ನೀಡಿದರು. ಅಂದರೆ ನಾನು ಟ್ರಾನ್ಸ್ಫರ್ ಆಗಿ ಹೋಗಲು ಲಗೇಜ್ ಶಿಫ್ಟ್ ಮಾಡಲು ಅವಶ್ಯವಿರುವುದರಿಂದ ಇವರುಗಳು ನನಗೆ ಇಂದು ಸುಮಾರು 1 ಲಕ್ಷ ಹಣ ನೀಡಿರುತ್ತಾರೆ. ಉಳಿದದ್ದು ನನ್ನ ಹಣವಾಗಿರುತ್ತದೆ.
One. P6 ನನ್ನ ಮನೆಯಲ್ಲಿ ಸಿಕ್ಕ ಹಣದ ಬಗ್ಗೆ ಸಮಜಾಯಿಷಿ. ಫೋರ್ ಇಲ್ಲ, ಅದು ಇರೋದೇ ಒಂದು ಪಾರ.
ನೆಕ್ಸ್ಟ್ ಪ್ಲೀಸ್.
ಮನೆಯಲ್ಲಿ ಸಿಕ್ಕ ಹಣದ ಬಗ್ಗೆ
ದಿನಾಂಕ
ಸಮಜಾಯಿಷಿ.
30 ನೆಕ್ಸ್ಟ್ ಪೇಜ್. ದಿನಾಂಕ 30/11/2016 ACB ರವರು ನಮ್ಮ ಮನೆಗೆ ಭೇಟಿ ನೀಡಿದಾಗ ನಮ್ಮ ಮನೆಯ ಅಂದರೆ ನಾನು ರೆಂಟಿಗೆ ಇದ್ದ ಮನೆಯಲ್ಲಿ ನಾನು ಟ್ರಾನ್ಸ್ಫರ್ ಆಗಿ ಹೋಗಲು ಎಲ್ಲಾ ಸಾಮಾನುಗಳು ಕಟ್ಟಿ ಇಟ್ಟಿದ್ದೇನು. ನಮ್ಮ ಮನೆಯಲ್ಲಿ ಯಾವುದೇ ಹಣವಿರಲಿಲ್ಲ. ಆದರೆ ಒಂದು ಬ್ಯಾಗಿನಲ್ಲಿ ಹಣ ಇರುವುದನ್ನು ACB ರವರು ಗಮನಿಸಿದರು. ಅದರ ಬಗ್ಗೆ ನನಗೆ ಯಾವುದೇ ಮಾಹಿತಿ ಇರುವುದಿಲ್ಲ.
ಅಷ್ಟೇನೆ, ಎರಡೇ ಎಕ್ಸ್ಪ್ಲನೇಷನ್ ತಾನೆ.
One more is at page 308.
ಅದು ಯಾವುದು?
Exhibit P6 I think.
P6 ಇಲ್ಲಲ್ಲ, ಅದೆಲ್ಲಿಂದ ಬಂತು? ನೋಡಿ ಅವ್ರು ಹೇಳ್ತಾ ಇರೋದು P4 ಆದ್ಮೇಲೆ 6 ಇದೆ ನೋಡಿ.
I think they have marked the wrong document.
ಇದೆಲ್ಲ ಎಲ್ಲಿಂದ ಬರುತ್ತೆ ನಿಮಗೆ?
This was the letter addressed to the IO minutes.
That is not in the original file.
It's not there.
Those documents could be part of paper book. Who is responsible for that?
It's appellant minutes. We have filed the paper book minutes.
That is why I am asking, who is responsible? If I were to rely on the paper book and proceed, what should happen? ಅಲ್ಲಿ ಏನೋ ಸರ್ಟಿಫಿಕೇಟ್ ಕೊಡ್ತೀರಲ್ವಾ ನೀವು ಪೇಪರ್ ಬುಕ್ ಆದ್ಮೇಲೆ?
This minute.
ಎಂಡಿಗೆ what is the certificate?
My earlier counsel has obtained.
ಯಾರಾದ್ರೂ now you have stepped into the shoes.
Please Manoj.
You cannot disown your responsibility.
No.
Yes. very serious, development. Now P4 is there, P6 is there. They are the earliest version of the accused.
Please.
They do not tally with your evidence of DWs 1 to 5 or 6.
1 to 6.
Inconsistent. Now, what is your contention?
That's my contention is, my lords. First one, my lords, the complainant had no work before me, my lords.
No, is it the requirement of law?
No, my lords, my contention. Let's what?
Is it the requirement he should have 7 and bandilla?
No, my lords.
Then.
Please.
You have nothing to do with that.
Please. That's thereafter there was no demand and acceptance, my lords.
Please read 13(1)(d). Yes.
Madam.
13(1)(d) na? 2.
A public servant is said to commit the offense of criminal misconduct if he, by corrupt or illegal means, obtains for himself or any other persons any valuable thing or pecuniary advantage, or by abusing his power, by abusing his position as public servant, obtains for himself or any other person any valuable thing or pecuniary advantage, while holding office as a public servant, obtains for any person any valuable thing or pecuniary advantage without any public interest.
So there is no reference to either demand or pendency of work, nothing.
Yes.
You by corrupt means obtain something. E, why 13(1)(e) is not applicable?
Here he is in possession at the time during the period of his office for his entire tenure they check it.
ಅದು ನೀವು ಅಲ್ಲಿ ಮಾಡ್ತೀರಿ, ಇಲ್ಲಿ why can't it be applied? Read it once again.
If he or any person on his behalf is in possession or has at any time during the period of his office
For that day.
Being in possession for which public servant cannot satisfactorily account of pecuniary resources or property disproportionate to his, or there is a word or used.
ಅದೇ property disproportionate ಇಲ್ಲ, pecuniary resources while he was in office.
And there is no tenure prescribed also for disproportionate.
Yes, that is what. There is no bar.
They could have added but the FIR doesn't have
explanation.
For purpose of this section, known sources of income means income received from any lawful source, and such receipt has been intimated in accordance with the provisions of any law, rules, or orders for the time being applicable to a public servant.
Here the cash declaration register. You have to point out the rules under which there is a rule to maintain.
There is a government rule.
Yes.
The circular issued by the government.
Yes.
But in terms of the imputed order, two issues have been raised. One is the sanctioning, the competence of the sanctioning authority and approving of obtainment. And perhaps the latest experience with the judgment, if we break down, obtainment has been defined by the demand emanates from the accused and he pays. Unlike acceptance.
Let him. Out mostly ಆಮೇಲೆ ನೋಡೋಣ.
My ground was, my lords, there was no demand and acceptance, my lords.
Demand, is it the requirement? Just now you read it.
Please, my lords.
Is there any word demand?
No, my lords.
Then.
My lords, with regard to the amount, my lords, defendant number 1 to 6 have been, defendant's witness have been defense witness have been examined, my lords.
But that is inconsistent with your own
Plus, that was the
explanation.
statement which was given before the IO, my lords.
It
At the point
assumes
of,
importance, sir. Earliest defense you have taken that. Earliest defense you have taken.
plus that was at,
It has more value than the evidence of these witnesses.
my lords, thereafter, my lords, I had withdrawn an amount of rupees 3,90,000.
ಅವೆಲ್ಲ ಬೇಡ ನಿಮ್ಗೆ explanation. You are not a layman.
Please, please.
You are an officer, responsible officer in the public office. And you have given the written explanation for the cash that was found in your office as well as in your residence
Please.
at the earliest point of time. And that both these exhibit P4 and 6 are in your own handwriting. You cannot disown that.
Okay.
And you have no explanation. You have not stepped into the witness box. And what is wrong in the trial court judgment then?
Plus, plus mere possession of amount does not prove.
So a public servant can have lakhs of rupees in his office, in his
No, my lords,
house, and he is not accountable for that.
No, he is accountable, my lords.
Then
For that, the explanation
ಅದನ್ನೇ
of
ಕೇಳ್ತಾ
defense,
ಇದ್ದೀನಿ.
ಅಲ್ಲ,
Where is
defense
the
evidence
reason
is, plus, that was at the time of raid, my lords. Even his mindset won't be in a proper way, my lords.
Was
And
it your defense?
My lords,
I was
our
not
defense
in
was
good
that
mind
statement cannot be accepted.
ಎಲ್ಲಿದೆ ಅದು? Position of law ಎಲ್ಲಿದೆ?
But our defense was that, my lords.
Defense, so it should be in accordance with law, sir. You
Please.
cannot, you are not permitted to take any defense.
Let's as per
It should be permitted under law.
Evidence Act 25, my lords, it
Hmm.
goes to says that it is confessional statement which cannot be accepted.
Was it
our
your
defense.
Is it a confessional statement?
No, my lords, but
Then why you are applying that?
my lords, that was at the time of raid, my lords.
Easy, sir. You should know the exact position of law.
Please.
You have given your explanation voluntarily in our own handwriting. Now why you are want to disown that?
My defense in the trial court was, my lord, that was forcefully
That is the subsequent defense taken.
during the course of the trial.
Yes.
Please.
And is there any explanation offered by you as to why you have given the explanation at the earliest point of time as per exhibit P4 and 6? And now why you are changing your defense as deposed by DW's?
For change of defense, we are not told anything.
Was it not necessary?
Please, it was.
Then which is to be preferred? Which defense is to be preferred? Naturally, the earliest defense we have to take into consideration.
Yes, but that was stated before the IO, my lords. At that point of time, other factors may be involved, my lords.
Whether there is cross-examination to IO in that line,
No, my lords.
Then-
In that line, it is not.
if it does not find a place in the cross-examination, what is the use?
That's for the amount, my lords, it was not, there was no question of demand and acceptance, my lords, I agree, my lord. It
Sir,
was-
how many times
It was,
I have
no,
to
my lords,
say-
I'm,
Demand is not the requirement of law.
please, my lords, but the amount which I had, my lords, I've given explanation through defense as well as my bank statement.
ಬ್ಯಾಂಕ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಎಲ್ಲ ಮೊದಲಿಗೆ ಇಲ್ಲ ಅದು.
Bank statement is,
ಅವ್ರು ಯಾರು ಪ್ರಮೋದ್ ಶೆಣೆಯಿಂದ 50,000, ರಾಜೇಶ್ ಇಂದ 50,000 ಹಣ ಪಡ್ಕೊಂಡಿದ್ದೆ, ಅದನ್ನ ಇಟ್ಕೊಂಡಿದ್ದೆ ಟ್ರಾನ್ಸ್ಫರ್ ಆದ್ರಿಂದ ಲಗೇಜ್ ಶಿಫ್ಟ್ ಮಾಡೋ ಕಾರಣಕ್ಕಾಗಿ. ಸೊ 1 ಲಕ್ಷ ಆಯ್ತು. 3,49,000.
but that defense is not there, my lords, I've taken a different stand.
No, I don't think you are having any ground.
Let's,
You are not permitted to take any inconsistent defense at the later point of time. There must be some explanation why exhibit P4 and 6 was given.
that's my ground was, my lords, it was during the, before the IO, and it was
And there is no cross-examination to IO.
not on that point.
Then leave it.
That's my ground is not mere possession of currency notes.
Mere possession is sufficient. Unexplained possession.
That's my explanation, my lords, is that your lordship may kindly see my bank statement, my lords. That is during that period, my lords. It is,
ಎಲ್ಲಿ ಹೇಳಿದಿರಿ ಸ್ವಾಮಿ ತಾವು ಬ್ಯಾಂಕ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅದು ಇದು ಇವ್ರು ಯಾರು DW1 ಬ್ರದರ್ ಇನ್ ಲಾ ಬ್ರದರ್ ಸಿಸ್ಟರ್ ಫ್ರೆಂಡ್ಸ್ ಇವರೆಲ್ಲರೂ ಇಷ್ಟಿಷ್ಟೆಲ್ಲ ಕೊಟ್ಟಿದ್ರು ಅಂತ. That is only at the fag end of the trial. It is quite afterthought.
no, my lords, during the course of the investigation, that is the letter which I was stating as exhibit P4.
ಎಲ್ಲಿದೆ ನಿಮಗೆ ಕಡೆಗೆ ಕೊಟ್ನಲ್ಲ ನಾನು
Please, please,
ಎಂಟೈರ್ ಪೇಪರ್ಸ್ ಕೊಟ್ನಲ್ವಾ?
Please, my lords. In that I have explained everything, my lords. That is before the trial.
ಇನ್ನೂ ಎಕ್ಸ್ಪ್ಲೈನ್ ಮಾಡಿ. I have absolutely no objection, but show me the explanation in the records.
I think this is part of the charge sheet, my lords. I will produce. Mark ಆಗಿಲ್ಲ.
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ನಲ್ಲಿ ಪ್ರಾಕ್ಟೀಸ್ ಮಾಡಿದ್ದೀರಾ ಅಥವಾ ಹೈಕೋರ್ಟ್ ಪ್ರಾಕ್ಟೀಸ್ ಮಾತ್ರ? We are finding it very difficult. Directly ಇಲ್ಲಿ ಹೈಕೋರ್ಟ್ ಅಡ್ವೊಕೇಟ್ಸ್ ಅಂತ ಬಂದು ಆರ್ಗ್ಯೂ ಮಾಡಿದ್ರೆ this is the problem we are facing. That is why it assumes importance, trial court practice.
Yes.
Anything and everything cannot be relied on by the appellate court. It is only these documents, these materials. ನೀವು ಓದ್ತಾ ಇರೋ ಲೆಟರ್ ಯಾವ್ದು? ಡೇಟ್ ಯಾವುದು?
There is no date, my lord. This is a letter, explanation to the letter dated 23/2017.
ಅಂತದ್ದು ಎಲ್ಲೂ ಎಕ್ಸಿಬಿಟ್ಸ್ ನಲ್ಲಿ ಎಲ್ಲೂ ಕಾಣಲ್ಲ. Yes. No such letter or exhibited. Not the part of our trial court records.
Please. That's my, to the explanation for the possession is, my lords, the defense witnesses and the bank statement, my lords.
Bank statement exhibit?
P25 minutes. Starts from page 359.
Exhibit P?
25, my lords. I have withdrawn a sum of rupees 3,90,000 from 1/9/2016 to 15/10/2016. my lords. This has not been considered by the trial court. This is not considered by the trial court. my lords.
That was not your explanation.
That's the demand is proved, my lords, by the defense evidence of prosecution witnesses, my lords. None of the witnesses have proved that they are either the employees or the owners of the factories.
You have cross-examined them.
Please, my lord.
Anything elicited during
They
cross-examination?
admit that the demand was done before in the month of so and so, and there is no proof or documents produced to show that they're employees of that factories which they claim, my lords. Either the owners or the employees, and they had not approached the police, my lords. Police had invited them. Thereafter, my lords, on the day of raid, my lords, 30/11/2016, the appellant had filed only 3 files. And they have not been examined. The 3 factories which the appellant had signed, my lords, they have not been examined. So the contention that the demand was from on the basis of the evidence of prosecution witnesses, my lords, is not proved, my lords.
Yes.
And the amount that they claim to have been paid to the appellant is in the month of October. That was before the note ban was initiated, my lords. So their evidence cannot be relied on, my lords.
Yes.
My lords, so on the one hand, even without any documents, the trial court accepts their evidence, rejects my evidence for defense evidence for not producing bank statements. So I've given explanation for 1,68,000. Thereafter, I've withdrawn a sum of rupees 3,90,000. I had that amount of which was seized with me, my lords. And there are reports against the prosecution witnesses where the factories were raided before the raid. And there was reports against them, my lords. So even there.
So all these things were within your knowledge when the raid was held?
Please.
You were very much aware of that?
Please.
You received the amount from your brother-in-law, brother, sister, friends, right?
Please.
And you are also knowing that you have withdrawn 3,90,000 or something.
3,90,000.
You are knowing that. What prevented you from giving the explanation?
During the course of the investigation, I've stated, my lords, not on 30/11/2016, my lords. On that day, that was the explanation, Exhibit P 4 and 6.
Yeah,
But
there must be some reasonable explanation.
that was on the day of raid, my lords, and it was by the IO. My contention is that, my lords, it was taken by force.
Where you have taken that contention?
During the argument in the trial court, my lords.
Defense is to be taken during cross-examination, or at least in 313 statement.
That is not
Not during the
cross-examined.
arguments.
That is not cross-examined to IO.
Arguments ಎಲ್ಲದನ್ನು ಕೇಳಲ್ಲ ನಾವು. If it is supported by materials on record, yes, the court is bound to consider that. Now you cannot improve your contention. On the basis of the materials available on record, you have to address the argument, not beyond that.
Please.
Yes, that's all.
Please.
Yes.
The word that comes to be used is by corrupt or illegal means obtains for himself.
But you have not invoked E.
E we have not invoked, my lords. I'm saying D1. The word obtain figures in D1, my lords.
Yes.
And what is obtain?
Demand.
My lords, demand, obtain includes demand is what the Supreme Court has now clarified.
Yes.
My lords, I'm giving a compilation of judgments, only 3 of them. In that, my lords, my lords may have running page number 46 of Neeraj Datta of the compilation, my lords. 46. After having discussed everything, the Honorable Supreme Court in terms of the Constitution Bench judgment has given these, what emerges from above aforementioned discussion is summarized as under. Proof of demand and acceptance of illegal gratification by a public servant as a fact and issue by the prosecution is a sine qua non in order to establish the guilt of the accused public servant. My lords may come to 88.4. In order to prove the fact and issue, namely demand and acceptance of illegal gratification by public, the following aspects have to be borne in mind. If there is an offer to pay by the bribe giver without there being any demand from the public servant and the latter simply accepts the offer and receives the illegal gratification, it is acceptance under section 7. He doesn't fall under this category. He falls under the next category. On the other hand, if the public servant makes a demand and bribe giver accepts the demand and tenders the demanded gratification, which in turn is received by the public servant, it is a case of obtainment. Now, incidentally, my lords, 13(1)(d) refers to not just obtainment, it also refers to obtain, my lords. Next para is important. In both the cases above, the offer by the bribe giver and the demand by public servant respectively have to be proved by prosecution as a fact and issue. In other words, mere acceptance or receipt of an illegal gratification without anything more would not make it an offense under 7 or section 13(1)(d) respectively. Therefore, under section 7 of the Act, in order to bring home the offense, there must be an offer which emanates from the bribe giver, which is accepted by the public servant, which would make it an offense. Similarly, a prior demand by the public servant, when accepted by the bribe giver, and in turn there is a payment made, which is received by the public servant, would make an offense of obtainment under 13(1)(d)(1). Now, how it has to be proved is in the next page, my lords. The presumption of fact, my lords, here section 20 presumption doesn't kick in, it's the 114 presumption. That is there in the latter paragraph also, because 7 is not included for 20 to kick in. The presumption of fact with regard to demand and acceptance or obtainment of an illegal gratification may be made by the court of law by way of an inference only when the foundational facts have been proved by relevant oral and documentary evidence and not in the absence thereof. On the basis of material on record, the court has the discretion to raise a presumption of fact while considering whether the fact of demand has been proved by the prosecution or not. Of course, a presumption of fact is subject to rebuttal by the accused, and in the absence of rebuttal, presumption stands. Now, next, my lords, 88.6. In the event of complaining turning, this is not relevant here, my lords. The next one, 88.7. Insofar as section 7 of the Act is concerned, on proof of the facts in issue, section 20 mandates the court to raise a presumption that the illegal gratification for the purpose of motive or reward, as mentioned in the said section. The said presumption has been raised by the court as legal presumption or a presumption in law. Of course, the said presumption is subject to rebuttal. Section 20 does not apply to 13(1)(d) and 2 of the Act. Here, that is why, my lords, 114 presumption comes. Next, my lords, we clarify that the presumption in law under section 20 of the Act is distinct from the presumption of facts referred to above in para 88.3 above, as the former is mandatory presumption while the latter is a discretionary in nature. Now, my lords, my respectful submission is what has to be proved for this honorable court or the trial court to draw a presumption would be, my lords, the foundational facts. And the foundational facts, my lords, in terms of deposition by more than one person is to the effect that he has specifically demanded a specific sum of money and we have given him that, and for a specific purpose as well. Now, this having been proved, my lords, that there is the, I'll point out, my lords, in terms of the deposition of P3, P4, P5 and P6, my lords, that he has demanded for renewal of license and has received respective sums. Now, given this scenario, my lords, a presumption necessarily needs to be drawn. Not to mention, my lords, during the time of the raid, these are all secured in separate packets. My lords, a very strange thing is, it is there as a part of the original records, also it can be seen right from here that there were envelopes, different envelopes in having different amounts of money. And those are all part of the search mahazar as well. If the contention of the petitioner, appellant herein is to the effect that it is his money, there needs to be an explanation as to why different amounts was kept in different envelopes as such.
To pay it to the different persons.
To have received it from different persons. Rather, that is why, my lords, all of these leave a lot of different interpretations. That is why a presumption is cast on him and he has to prove it beyond, he has to rebut the said presumption, is my respectful submission. My lords, finally, one subtle issue that has been raised because I've given the compendium of judgments. In terms of the pleadings of the appeal memorandum, my lords, a contention is raised that the sanctioning authority is not the designate authority to give sanction. Now, there is a specific contention taken, my lords, that he is appointed by under the hand and seal of the governor. So the cabinet, because the word government comes in, the cabinet has to give the sanction as the interpretation, at least the minister. Here, my lords, it has been approved by the principal secretary of the concerned department. So, my lords, there is one judgment, though it goes against me, my lords, I would. There is a recent judgment which we have taken in appeal, and the appeal is pending, my lords. Lakshman Rao Peshwe. My lords, I have enclosed it. My lords, a learned single judge of this honorable court was pleased to hold that it is the appointing authority alone which has to give sanction. And due to that, my lords, the principal secretary is not a designate authority. It has to be the cabinet of the government is what was given, my lords. However, to counter that, my lords, because the pleadings were raised, we have relied on two judgments, my lords. It is incumbent upon them to show as to what is the prejudice caused. My lords may please have the judgment in terms of compilation, page number 49, it starts, my lords. State of Karnataka versus S. Subbegowda. Paragraph 19, my lords, the running page number 57, my lords may please have. Thus, it is clear from the language employed in subsection 3 of section 19 that the said subsection has application to the proceedings before the court in appeal, confirmation or revision, and not to proceedings before the special judge. The said subsection 3 clearly forbids the court in appeal, confirmation or revision the interference with the order of the special judge on the ground that the sanction was bad, save and except in cases where the appellate or the revisional courts finds that the failure of justice has occurred by such invalidity. Even with going, my lords, that a protection is given to them under the Peshwe judgment, saying it is not that designate authority, they have to specifically show that there is some kind of injustice caused. That's my specific contention. My lords, the other judgment therein, my lords, is the Vinod Kumar Garag judgment, which starts at page number 61. Please.
Which is the other one? The other one?
My lords, the first one I read out was at page number 49. It was starting. That's the 2023 judgment. And the other one, my lords, runs at page number 61. Vinod Kumar Garag versus State Government of National Capital Territory, Delhi. Again here, my lords, the relevant paragraph, my lords, will find at page number 28. This court in Ashok Bhutia versus State of Sikkim, referring to earlier precedents, has observed that a defect or irregularity in investigation, however serious, page number 75 of the running page number 75. The judgment starts at 61. My apologies, my lords.
Para number?
Para number 28, my lords. This court in Ashok Bhutia versus State of Sikkim, referring to the earlier precedents, has observed that a defect or irregularity in investigation, however serious, would have no direct bearing on the competence of the procedure relating to cognizance or trial. Where the cognizance of the case has already been taken and the case has proceeded to termination, the invalidity of the precedent investigation does not vitiate the result unless a miscarriage of justice has been caused thereby. Similar is the position with regard to validity of sanction. A mere error, omission, or irregularity in the sanction is not considered to be fatal unless it has resulted in failure of justice or has been occasioned thereby. Section 19(1) of the Act is matter of procedure and does not go to the root of the jurisdiction. And once the cognizance has been taken by the court under the code, it cannot be said that an invalid police report is the foundation of the jurisdiction of the court to take cognizance, and for that matter, the trial. So, my lords, in terms of pleading, they had taken this contention. That is why I had to address it. It should not happen, my lords, later on at an appellate stage. Again, it is raised that the court has not, this appellate court has not addressed it. So, my respectful submission, my lords, is firstly to say that obtainment, there is only a demand and acceptance that has to be proved. And in terms of deposition of PW 4, 5, and 6, it is unequivocally proved, my lords, that he specifically asked a certain amount and he has received the said amount. Given the proving of these foundational facts as per Neeraj Datta, my lords, a presumption has to be drawn under section 114 to take, and even also other circumstances to include, my lords, the fact that amount was seized from him. And post that presumption, there is an explanation or rebuttal that has to happen from his end, which has happened to the effect, my lords, that he received money from 4 people.
Which is the relevant presumption under 114?
My lords,
there are various presumptions.
Evidence Act. Adjustment to court may presume existence of certain facts. The court may presume the existence of any fact which it thinks likely to have happened, regard being had to the common course of natural events, human conduct, and public and private business in their relation to the facts of the particular case. My lords, illustrations have been given. The court may presume that a man who is in possession of stolen goods soon after the theft is, please, my lords, stolen baralla, that an accomplice baralla, that a bill, that a thing or state of things which have been shown to be in existence within a period shorter than within which such things or state things usually cease to exist is still in existence. The Judicial and Official Act, that the common course of business has been followed in particular cases, that evidence which would be and is not produced would, if produced, be unfavorable to the person, that if a man refuses to answer a question which he is not compelled to answer, that when a document creating an obligation is in the hands of the obligor, the obligation has been discharged. My lords, other than the illustrations which are given, which would not be exclusive, my lords, my respectful submission is if the interpretation of the section itself goes into it, the court may presume the existence of any fact which it thinks likely to have happened. My lords, if we read it in context with the Neeraj Datta judgment, once the foundational facts of demand are proved, that yes, there is a deposition to the effect that there was a requirement of revalidating their license as such, at that point in time there is a demand, then there is a presumption drawn, my lords, that this money is in connection with the demand itself. I'm taking recourse to 114, my lords, because of the simple reason that only 13 has been invoked here and section 20 doesn't kick in. I'm left with no option but to go back to 114.
Yes.
And their rebuttal, my lords, of the presumption, the trial court has dealt with very clearly. The impugned order, the paper book at page number 91, my lords, clearly calculates the total amount that was seized from him and holds that there is still no explanation forthcoming in as much as 26 notes are concerned. Even assuming, my lords, with an explanation that whatever the DW1 and DW4 have said is true. My lords, that the page number 36 of the impugned order, it says, for the sake of discussion, even if the evidence of DW1 to DW3 and DW6 is accepted as it is, then at the most it can be held that the accused received 28 notes from DW1, 26 notes from DW2, 10 notes from DW6, and another 20 notes from DW3, which they do not note here. There was 110 notes of new currencies of 2,000 rupees in the possession of the accused as on 30/11/2016. Therefore, at the most, evidence of DW1 to DW3 and DW6 shows the explanation of 84 notes, and there is no account of remaining 26 notes of new currency. The value of 26 notes is 52,000 rupees. This is clearly dealt with by the trial court. Not to mention, my lords, the trial court goes in pains to even
DWs 1 to 6 explain about 84 notes.
84 notes.
Remaining
26 notes are left. Not to mention the other denominations, my lords. We are only talking about 2,000. I'm saying, my lords, he has not been able to even rebut the presumption that is drawn, is my respectful submission. More so, my lords, the 2001, the trial court goes to traverse the central government's notification as regards demonetization. And it also says on a particular day, you could draw only a certain amount of money. So it necessarily shows, my lords, that it was drawn by different people and given to him.
that is exhibit P47. What is this? Letter of Reserve Bank of India. Much earlier.
That is the details of the notes, my lords. To that, my lords, I object. When they seized the notes, my lords, the note numbers were not recorded from my thing, my lords. So exhibit P47 cannot be relied, my lords.
In 47 ಅಲ್ಲಿ ಏನಿದೆ?
47 is the details of the notes, my lords. ಯಾವ ATM ಯಾವ ಬ್ಯಾಂಕ್ ಇಂದ ಬಂದಿದೆ ಅಂತ. While seizing the notes with me, my lords.
Incidentally.
No, my lords.
It is to be ignored.
The notes which I had, the numbers were not recorded, my lords.
So you have not given any explanation. You are the best person to explain the source of the currency notes which were found in your possession. You are the best person.
Later on, I have given, my lords. Not the only thing is, my lords, on 30/11/2016, my lords, during the raid.
All the difference.
During the raid, my lords, even my mindset won't be in a proper way, my lords.
Let us assume, as he has stated, 84 notes that were spoken to by the DWs.
But I had
remaining.
I had exchanged it, my lords. I had withdrawn.
Stated that.
I had withdrawn a sum of rupees 3,90,000, my lords.
Who has spoken to about that?
Yes, I have stated.
Is there any oral evidence?
not by me on stepping into the
Is there
box.
any statement in writing by you?
Plus, the exhibit which I was relaying, Malas, is not part of the.
So by merely looking at the exhibit, we have to presume. You have
But-
withdrawn the amount from this.
No, Malas,
so-and-so,
exhibit P25.
kept it in your office. or
Malas,
your
exhibit
house.
P25 shows that I had withdrawn the amount, Malas.
Yes, but who has to say that you have retained that amount and kept it in your office, kept it in your house?
My money presumption
Is
is that
it
I'll be in possession.
Is it a
Malas.
matter for presumption?
Plus, money which I have withdrawn, presumption would be in my possession. The amount would be in my possession, Malas.
Yes, sorry. Good.
Malas, insofar as demand is there, Malas, there is inconsistency. Malas.
Yes. ಇದು opinion ಮಾಡ್ಕೊಡಿ.
I'll rely on two judgments, Malas.
ಕೊಡಿ, ಕೊಡಿ.
That is with regard to possession does not prove.
Yes. ಕೊಡಿ.
Lords, Neeraj Datta has dealt with it. I didn't want to tax this court by reading it. Lords, Neeraj Datta came to be answered at a certain point, and those three judgments were there, which the Supreme Court calls as a trinity of judgments. Compilation.
15, 16. This is referred to in Neeraj Datta.
Please, my lords.
Yes. ಯಾವ್ದದು particular para?
I'll show it.
Satnarayan is referred.
My lords, page number, running page number 22 of my compilation. Trilogy of cases is what Supreme Court addresses it as, and deals with Jairaj, deals with Satnarayan Murthy, and then deals with M. Narsingh Rao. My lords have it on internal page 752. These are the three judgments, my lords. Jairaj and Satyanarayan Murthy being on one footing, and Narsingh Rao being on a different footing.
Yes, be seated.
Please, deeply.
The appellant being the accused in special case number 136 of 2017 on the file of the learned third additional district and sessions judge and special judge for the case under PC Act, Dakshina Kannada Mangaluru, is impugning the judgment and judgment of conviction and order of sentence dated 3rd December 2022. Convicting him for the offence punishable under section 13(1)(d) read with section 13(2) of PC Act and sentencing him to undergo simple imprisonment for 4 years to pay fine of ₹4,000 with the default sentence. It is the case of the prosecution that the accused, who was working as assistant director of factories at Kottara, Mangaluru, was a public servant. He demanded and accepted illegal gratification of ₹3,49,550 from many factory owners on 30/11/2016 and got the money from corrupt or illegal means, thereby committed criminal misconduct punishable under section 13(1)(d) read with section 13(2) of PC Act. To prove this contention, the prosecution, it is stated that EW1, a right-spirited person, lodged first information as per Exhibit P1 with Lokayukta police stating that he received credible information that the accused, being the public servant, demanded and accepted illegal gratification from various factory owners or employees for the purpose of renewing the license. And therefore, he requested the police to register the case and to initiate action. On the basis of the same, the FIR as per exhibit P28 was came to be registered. A search warrant was obtained. A raid was held on the office of the accused and as well as on his residence. Separate measures were drawn for having recovered the cash found in the office as well as in his residence. It is the contention of the prosecution that the sum of rupees 3,49,000, 1,12,865 and one silver coin was found in his office premises. And when this house was searched, cash of rupees 2,36,650 was found. Thus, the accused was in possession of 3,49,515 as on the date of raid, and it is according to the prosecution, the illegal gratification due to his obtained by him and thereby committed misconduct. The investigating officer completed the investigation by taking the explanation by the accused as per exhibit P4 and 6. Separately, when the cash was found while holding raid on his office and the house separately, and the a final report was came to be filed after obtaining sanction. Sanction ಆಗ್ತಕ್ಕಂತಹ sanction exhibit, sanction order. Sanction as per exhibit so and so. The learned magistrate took cognizance of the offence and registered the special case 136 of 2017. The accused appeared before the trial court and pleaded not guilty. 27. Yes. Pleaded not guilty. Prosecution examined PWS 1 to 11, marked exhibit P1 to 48, and identified MOs 1 to 13 in support of its contention. The accused denied all the incriminating materials in his statement under 313 of CRPC. Got examined DWs 1 to 6 in support of his defense. The trial court, after taking into consideration all these materials on record, came to the conclusion that the prosecution is successful in proving the guilt of the accused beyond reasonable doubt and accordingly passed the improved judgment of conviction and order of sentence as referred above. Being agreed by the same, the accused is before this court. Third so and so. Very useful. My answer to the other point negative for the following reasons. It is the contention of the prosecution that the accused was a public servant as he was working as the assistant director of factories at Mangaluru. It is an admitted fact. It is the further contention of the prosecution that PW1 had filed the First information as per Exhibit P1 with Lokaयुक्त police stating that he had received credible information regarding accused demanding and accepting illegal gratification from the owners oblique employees of various factories for the purpose of renewal of their license, on the basis of which FIR was deemed to be registered. Search warrants were obtained. And the raids were held on the office of the accused as well as his residence. Two different Mahzars. Office nalli yavadu Mahzar Exhibit P2 na? P3.
14 is a house. Which is later rated than there some 2 lakhs.
Yes. Residence. A Mahzar was drawn as per Exhibit P3 in his office, where cash of rupees 1,12,865 with a silver coin were seized. When the search was held in the house of the accused, cash of rupees 2,36,615 was recovered, and the Mahzar as per Exhibit P14 was drawn. Search and seizure and recovery of the cash as referred to in Exhibit P3 and 14 is also not in dispute, as the learned counsel for the appellant has never raised such a dispute. On the other hand, he conceded that such a raid was held and the cash belonging to the accused were seized. It is the specific contention of the learned counsel for the appellant before this court that the accused has explained the source of this money properly, and therefore the trial court was not right in convicting the accused. He refers to the evidence of DW1, the brother-in-law of the accused, who states that he had given rupees 56,000 to the accused, that is 28 currency notes of rupees 2,000 denomination. DW2, the brother of the accused, who deposes that he had given 52,000, that is 26 currency notes of rupees 2,000 denomination. DW3, the sister of the accused, who deposed that she had given rupees 40,000 to the accused, that is 20 currency notes of rupees 2,000 denomination. DW6 is the friend of the accused, who deposed that he had given rupees 20,000, that is currency note, 10 currency notes of rupees 2,000 denomination. Even if even if the evidence of these witnesses are to be accepted, they explain about paying of in all rupees 1,68,000 to the accused as on the date of raid. But the cash recovered in the office and the house is totaling to rupees 3,49,515. There is absolutely no explanation for the same offered before the trial. Next one. The counsel for the accused contended that Exhibit P25 is the bank statement pertaining to the accused, according to which the sum of rupees 3,90,000 was drawn by the accused from 1/9/2016 to 15/10/2016. And therefore, it is also to be taken as explanation by the accused regarding the remaining amount found during the raid. But unfortunately, except Unfortunately, this exhibit P25 was court marked by the prosecution. The accused had never taken any defense that the cash withdrawn during the period from 1/9/2016 to 15/10/2016 was retained by him either in his office or in his house for his personal expenses. It is only for the first time such a defense was raised by the learned counsel for the appellant. On perusal of the statement of the accused recorded under section 313 of CRPC, no such explanation is forthcoming, as he has only denied the incriminating materials and stated that a false complaint was registered against him and a false charge sheet was filed by the investigating officer. It is also pertinent to note that the accused had never stepped into the witness box to speak about his defense. Next. It is relevant to refer to Exhibit P4, the explanation letter given by the accused at the earliest point of time, that is on 30/11/2016, when the raid was held in his office and cash of rupees 1,12,865 was recovered. As per Exhibit P4, which is in his own handwriting, the accused stated that he had received cash from one promotional and Rajesh, who received cash of rupees 1 lakh from his friends promotional and Rajesh, and that was kept in his office for the purpose of transfer of his for the purpose of shifting his luggage from Mangaluru to Bengaluru. He states that the balance amount belongs to him. Exhibit P6 is the similar explanation found in the handwriting of the accused, given by him after a raid and after search and seizure in the house of the accused, where cash of rupees 2,36,615 was found. The explanation given by the accused, offered by the accused, is that he has no clue about the cash that was found in his house. It is not in dispute that the premises was in exclusive occupation of the accused, but he disowns any information about the same. It is pertinent to note that explanation offered at the earliest point of time, that is on the date of incident, as per Exhibit P4 and 6, were given a go-by by the accused while offering his own explanation by examining DWs 1 to 6. The explanations given by the accused, as spoken to by DWs 1 defense evidence, is quite contrary to his earliest explanation, Exhibit P4 and 6. There is absolutely no explanation as to why there was such inconsistent defense taken by the accused. Next, the counsel for the appellant contended that since the raid was held in the office and the house of the accused, and the investigating officer asked the accused to give the explanation, he could not give the proper explanation out of fear. He further submitted that the investigating officer might have taken the explanations, Exhibit P4 and 6, forcibly. Even the learned counsel for the appellant was not sure about this defense. However, this was not the defense taken before the trial court. There is absolutely no cross-examination even to the investigating officer, who is examined as PW1 in that regard. Under such circumstances, the defense taken by the accused is to be disbelieved. Next, PW 3, 4, 5, 6, and 9 are either employees or the owner of various factories. These witnesses have categorically stated about the demand, acceptance of illegal gratification by the accused. Even though these independent witnesses were cross-examined by the learned counsel for the accused at length, nothing has been elicited from them. There is absolutely no reason as to why their version is to be disbelieved. There, on consideration of the evidence of PW 3, 4, 5, 6, and 9, the contents of the first information, Exhibit P1, gets support. It is further strengthened with the raid held on the office and the house of the accused, seizure of unexplained money of rupees 3,49,515 under two different measures, Exhibit P3 and 14. Next. When the accused admits that he is a public servant working in the government office, the raid was held in his office and found the cash of rupees 1,12,865. And raid was held in the house and found rupees 2,36,615. It was the bounden duty of the accused to explain the same. Once the prosecution discharges its burden of proving demand and acceptance of illegal gratification and recovery of such illegal gratification during search and seizure. But the accused has not offered any explanation, and even though he has offered explanation as per Exhibit P 4 and 6, and the evidence of DWs 1 to 6, they are quite contradictory to one another and therefore cannot be accepted. It is also pertinent to note that even if the explanation offered either in Exhibit P4 and the depositions of DWs 1, 2, 3, 6 is to be accepted, still the amount that was recovered under the Mahazars Exhibit P3 and 14 exceeds such explanation, and there is no explanation for the remaining balance amount recovered under the Caesar Mahazar. Next one. It is a matter of it is an admitted fact that the accused is working as a public servant in a government office. He is required to maintain a cash declaration register as per rule. You have to give that rules, corresponding rules. Requirement to maintain cash register, cash declaration register. So and so. Admittedly, the accused who was working as assistant director of so and so never maintained any such register to declare the cash. Declare the cash. All these facts and circumstances unmistakably point the accusing finger towards the accused regarding commission of the offense. Even though the accused is charged for the offense under section 13(1)(b), 13(2) of the PC Act, for which the presumption under section 20 of PC Act is not applicable. But however, as per section 114 of the Evidence Act, the court may presume existence of any fact which it thinks likely to have happened, regard being had to the common course of natural events, human conduct, in public and private business in their relation to the facts of a particular case. I do not find any reason for not invoking section 114 of the Indian Evidence Act. When counsel for the respondent places reliance on the decision of the apex court in Neeraj Datta versus State Capital Government of NCT Delhi 2023 4 SCC 731, wherein the Honorable Apex Court, after discussing at length about the position of law on the subject and referring to various its earlier decisions, summarized the position of law in para 88 as under. ಅಲ್ಲಿ ಅಂಡರ್ಲೈನ್ ಮಾಡಿದ್ದನ್ನು ಅಂಡರ್ಲೈನ್ ಮಾಡಿ. Thus, a prior demand by the public servant, when accepted by the bribe giver, and in turn he paid the amount which was found in the possession of the accused, amounts to obtainment as referred to under section 13(1)(d) 1 and 2 of the Act of the PC Act. And thus he has committed criminal misconduct punishable under section 13(2) of PC Act. Next, none of counsel for the appellant has placed reliance on the decision of the apex court in B. Jairaj versus State of Andhra Pradesh 2014 Part 13 SCC 55, C. Satyanarayana Murthy versus State of AP 2015 10 SCC 152, and M. Narsingh Rao versus State of AP 2001 1 SCC 691. All these decisions were referred to by the apex court in Neeraj Datta, Supra, as the same were referred in the order of preference in M. Narsingh Rao. The court observed that once the fundamental facts were proved by the prosecution, the presumption for payment or acceptance of illegal gratification was applicable. If the presumption is not rebutted by the accused, the fact of demand was proved. Consequently, the legal presumption was to be drawn that the said gratification was accepted as a motive or reward for showing the official favor. In M. Narsingh Rao, it is held that the court is bound to draw the legal presumption regarding acceptance of illegal gratification as a reward for doing the public duty once the primary facts are proved by the prosecution. The apex court referred to its decision in B. Jairaj in P. Satyanarayana Murthy Supra, Erduku Supra. Held that proof of held that the demand of proof, sorry, proof of demand. Proof of demand is a sine qua non for an offence under section 7 of PC Act. However, it proceeded to observe that in P. Satyanarayana Murthy, the materials on record disclose that the prosecution has failed to prove the demand of illegal gratification, and thus the conviction of the accused was held to be unsustainable. In view of the decision of the Constitutional Bench in Meerut Dutta, the controversy is laid to rest. Laid to rest. If the said settled position of law is applied to the facts in the present case, I have no hesitation to hold that the prosecution has successfully proved the guilt of the accused beyond reasonable doubt, but the accused has not taken any probable defense and therefore he is liable for conviction. Next. Learned counsel for the respondent submits that even though the learned counsel for the appellant has not raised the ground of lack of proper sanction to prosecute the appellant, before this court, such a defense was raised before the trial court, and such a ground is also raised in the memorandum of appeal. Therefore, he places reliance on the decision State by Lokaयुಕ್ತ Police, Bangalore Rural versus Subbegowda, 2013, SCC Online, Karnataka 10858. Subbegowda, 2023 R17 SCC 699. ಹೆಸರು ಸ್ಟೇಟ್ ಆಫ್ ಕರ್ನಾಟಕ ಲೋಕಾಯುಕ್ತ ಪೊಲೀಸ್ ವರ್ಸಸ್ ಎಸ್ ಸುಬೇಗೌಡ. Where the Honorable Apex Court considered the defense taken by the accused with reference to section 19 of the PC Act and held in para 19 as under. He also referred to the decision of the Apex Court in Vinod Kumar Garag versus state bracket the government of National Capital Territory of Delhi 2020 2 SCC 88, where the Apex Court again considered the validity of the sanction and held in para 28 as under. In the present case, PW10 is the assistant executive in the Labor Department who accorded sanction to prosecute the accused as per Exhibit P27. No prejudice is highlighted by the accused even when the trial court took cognizance of offense, trial was proceeded with. The sanctioning authority is examined as PW10 and he was cross-examined at length. And there is nothing on record to show that there was miscarriage of justice by accepting such sanction. Under such circumstances, I do not have any hesitation to reject the claim of the claim of the accused that the sanction was bad under law. From the discussions held above, I am of opinion that the prosecution is successful in proving the guilt of the accused and he is liable for conviction. I have gone through the impugned judgment of conviction and order of sentence passed by the trial court. I do not find any reason to avoid. It has taken into consideration all the materials on record and arrived at a right conclusion. I do not find any reason to interfere with the same. Hence, I answer the point will be negative and proceed as the following. Appeal is dismissed.
Obliged, my lords.
13, K. Chandrasekhar, connected matter in Dinesh Rao.
In view of disposal of criminal appeal, IA1 of 2023, first day stands dismissed. Yes, who is the appellant in 741?
That's 41, I think.
Yeah, accused number.
Lords, may I make one submission? This matter, my lords, I repeatedly checked with the office, my lords. Paperwork is not available for the respondent. Made my lords request. Repeatedly I have made.
Please go through the original records and proceed. Last time also I said.
Yes, yes, my lords.
Then
I
every
did, my
time
lords.
you are making the same
No, my lords,
submission.
I made, my lords.
What is the difficulty in going through this?
Voluminous ಇದೆ ಸ್ವಾಮಿ. It will take some time, my
ಏನು
lords.
voluminous ಇದೆ? ಅದು
Paperbook
ಬೇರೆ
4
ಇದೆಯಾ?
volumes ಇದೆ ಸ್ವಾಮಿ.
ಆಯ್ತು.
My lords, my only request.
Last time same submission was made.
Last time they made a
Voluminous ಇದೆ ಅಂತ
submission.
ಪ್ರತಿ ಸಲ ಅದನ್ನೇ ಹೇಳೋದು ಹೋಗೋದು.
Sorry, my lords, this is the only case, my lords. I am finding it difficult to secure the paperwork.
Sir, repeatedly I am saying, go through the original records. The appeal is of the year 2011.
Yes, my lord. Lords, I'll make one thing, my lords.
Permitted you to go through it. Then
Lords, voluminous.
you are making the same submission every time.
First time, my lords, for this case, I'm making this submission, lords, because last date your lordships had.
Yes, Mr. Hegde, ready?
So I'm appearing in the connected matter, 790.
Seven?
790.
That is accused number
Accused number 2.
724.
For the appellant.
Yeah, accused number.
1.
Huh?
Accused number
Accused number
1.
1. Then 741.
741, accused number 5.
In all, how many accused?
Let's in all 5 accused. Accused number 2 is dead during the trial. It is abated against the accused number 3. Accused number 3 abated.
During trial.
Yeah.
What about 4?
Number 4 appeal had to be.
Judgment. Judgment is related. Four has not preferred any appeal. Appeal nodi. I'll pass over the matter. Please look into that and assist the court.
Accused number 4.
Elladu on facts.
Agboth.
Pass over. Next.
May I request my lords at 2:30, my lords?
2:30.
2:30.
Yes, please.
230, kindly pass for accused number 5.
Next. 2:30. Next.
Serial number 14, R. Nagendra Nayak. Connected matter S. D. Bhagwan, Chetan B. P. Prasanna Kumar.
Some inconvenience today. Reposition copies ಇಲ್ಲ ನನ್ನ ಹತ್ರ.
ಏನು ಮಾಡ್ಲಿಕ್ಕೆ ಆಗಲ್ಲ. ಕೊಡಿ ಆರ್ಡರ್ ಶೀಟ್ ಕೊಡಿ.
ಅಲ್ಲ ನಾಳೆ ಮಾಡ್ತೀನಿ ಸರ್.
Last time
ಇಲ್ಲ
made the submission.
ಇಲ್ಲ ಲಾಸ್ಟ್ ಟೈಮ್ ಪೇಪರ್ ಬುಕ್ ಕಲೆಕ್ಟ್ ಮಾಡ್ತೀವಿ ಅಂತ ಅಲ್ಲಿ 2 ಸರಿ ಹೋದ್ವಿ. ಪೇಪರ್ ಬುಕ್ ಸಿಗದೇ ಇರಲಿ, ಐ ವಿಲ್ ಕಲೆಕ್ಟ್ ಇಟ್ ಫ್ರಮ್ ಅದರ್ ಅಡ್ವೊಕೇಟ್ ಅಂಡ್ ಐ ವಿಲ್ ಡು ಟುಮಾರೋ.
No, last time submission, when counsel for the appellant submits that he has collected the paper book and will address his arguments on the next day.
ಪೇಪರ್ ಬುಕ್ ರಾಂಗ್ ಮೇಲೂ
That's the submission.
ನಾನು ಮಾಡಿರ್ಲಿಲ್ಲ. ಮೈ
The
ಕಲೀಗ್ಸ್
other side ಏನ್ ಹೇಳ್ತಾರೆ ಅಂದ್ರೆ ಅವರು ಕರ್ನಾಟಕ ಇದು ಹೈಕೋರ್ಟ್ ರೂಲ್ಸ್ ಎಲ್ಲ ಹೇಳಿ ಪೇಪರ್ ಬುಕ್ ಮಾಡಿದ್ದೆ ನನಗೆ ಗೊತ್ತಾಗ್ಲಿಲ್ಲ ಅಂತ.
ಇಲ್ಲ ಪೇಪರ್ ಬುಕ್ ಇವಾಗ ಅವರು ಭಗವಾನ್ ಅವ್ರು ಹೇಳಿದ್ರಂತೆ, ನನ್ನ ಹತ್ರ ನಾನು ಹೇಳಿಲ್ಲ.
ಬೇರೆ ಮಾಡಿದ್ದೀನಿ. That is in criminal appeal 69 of 12.
ಇಲ್ಲ ನನ್ನ ಹತ್ರ ಈಗಲೂ ನೋಡ, ಐ ವಿಲ್ ನಾಟ್ ಮೇಕ್ ಫಾಲ್ಸ್ ಅಕ್ಯೂಷನ್. ಇವತ್ತು ನನ್ನ ಹತ್ರ ಪೇಪರ್ ಬುಕ್ ಇಲ್ಲ. ಈವನ್ ನೌ ಐ ಸೆಂಟ್ ಹಿಮ್. ಐ ಆಮ್ ಸಾರಿ. ಅಲ್ಲ ಅದು ಏನಾರು ಇರಲಿ, ನಾಳೆ ನಾನು ಮಾಡ್ತೇನೆ. ಇಟ್ ಮೇ ಬಿ ಟೇಕನ್ ಅಪ್ ಟುಮಾರೋ.
Where is Mr. Bhagwan?
ಅವರು ಬಿಕಾಸ್ ಏವನ್ ನೀವು ಫಸ್ಟ್ ಕಮೆಂಟ್ಸ್ ಮಾಡಿ, ನಾನು ಆಮೇಲೆ ಮಾಡ್ತೀನಿ ಅಂದ್ರು. ನಾಳೆ ಮಾಡ್ತೀನಿ.
Counsel for the appellant. ಇದು 107 ಅಲ್ಲಿ pays for a day's time and undertakes to address the argument tomorrow without fail. Appellant counsel for a connected ನಲ್ಲಿ absent no representation. Order sheet dated so and so. ಅದು ಉಳಿದಿದೆ ಎಲ್ಲದರಲ್ಲೂ no representation. You are appearing only in 107.
Yes,
I'm appearing for 101 now.
107 and
104.
104 2 A1 and A2.
A4.
14 and 14.3. ಅದನ್ನ ಹೇಳಿ. You are for?
A4 madam.
101 of 2012.
14.2 days for time, by days time. Counsel for 14.1 absent, no representation. Order sheet dated so and so, reads as enter. I do not find any reason to afford one more opportunity this time. Yes. Please come prepared. Yes.
Macha.
Serial number 15, Ramesh Kumar.
Good. Yeah, good. TCR. Good. Counsel for the appellant is absent, no representation. Order sheet dated so and so, reads as under. 16/6/2025 reads as under. In spite of that, there is no representation. Then an additional SPP is ready to address the argument. In view of the grounds raised in the memorandum of appeal, and since the counsel for the appellant is absent, I deem it appropriate to appoint a amicus curiae to assist the court in disposal of the matter on merits. So, Yaruno, appointed as amicus curiae. Office is directed to communicate this order to me. It is the learned amicus curiae and learned additional SPP are requested to address their arguments on the next state appearing without fail. Yes.
Serial number 16, SM Timrayappa.
Synopsis.
Yes. Yes, appellant sir.
My lord, appellants were called upon to face charges for offense.
A1 to 6.
No, A1 to 6.
1 to 6.
Of them, no.
Two is
My lord, A1, 3 to 6.
A1, 3 to 6.
3 to 6. A2 has been acquitted of all the offences.
What are the offense convicted?
Yes.
Offenses.
Offences, I mean, they faced offences punished under sections 143, 427, 436, read with 149. As my lord finds at page 105. Page 105, relevant page 106. All the accused, 106, first para in the middle. All the accused are sentenced to undergo simple imprisonment for a period of 3 months and to pay a fine of rupees 1,000 each. And in case of default, to pay fine amount, they shall undergo simple imprisonment for a period of 1 month each for the offense punished under section 143 IPC.
Yes.
Then accused number 1 is sentenced to undergo simple imprisonment for a period of 6 years and shall pay a fine of rupees 15,000. And in case of default to pay fine amount, he shall undergo simple imprisonment for a period of 1 year for the offense punished under section 436 IPC. Again, accused number 1 is sentenced to undergo simple imprisonment for a period of 1 year and to pay a fine of 4,000. And in case of default to pay fine amount shall undergo simple imprisonment for a period of 4 months for the offence punishment under section 427 IPC. No separate sentence is being awarded to accused number 1 for the offence under section 149 of the Indian Penal Code. Accused number 3, accused number 3, 4, 5, 6 are sentenced each to undergo simple imprisonment for 4 years and to pay a fine of 10,000 each. In case of default, each of them shall undergo 9 months simple imprisonment for the offence punishment in section 436, read with section 149 IPC. Accused number 3 to 6 are sentenced each to undergo simple
So
imprisonment.
different sentence for accused number 1
One.
and accused number 3 to 6. Yes.
Well, the prosecution examined 9 witnesses
Yes.
in order to prove the charges I read out before my lord just now, for which they have been convicted.
Yes.
PW1 is the complainant. PW2 is the son of complainant. Son of complainant, PW1.
PW1 is the complainant.
Complainant.
Ah.
Gaurama is the complainant.
Yes.
PW2 Manohar is her son.
Hmm.
PW3 Malaya is brother-in-law of PW1 Gaurama.
Hmm.
PW4 Kumar, an officer from the local village panchayat. PW5 is fire extinguisher.
Hmm.
Is from the fire extinguishing department. PW6 Sri Rangaya, head constable from the Kunigal police station.
Hmm.
PW7 is CPI of the same police station, Kunigal police station. PW8 is Mazhar witness, spot Mazhar witness. Exhibit P5. PW9 is Chennaya Hiremat, a PSI of the same police station.
Hmm. What is the role played by him?
Registered FIR.
FIR is exhibit P4.
He is registered.
Well, this was registered on 14/12/2009 at 7 p.m. Crime was registered on the complaint of PW1 at 7 p.m. of 14/12/2009 for offences punished under sections 143, 427, 436 and read with 149.
So PW7 is the
3-7 who registered the crime, head constable who registered the crime.
PW6. No, PW9 you said.
No. 6, PW6. PW6 is the person, head constable who registered the crime.
What is the role by PW7?
7 CPI who completed the investigation.
Laid the final report.
He filed charge sheet.
He filed the charge sheet into the committer court.
And what about PW9?
PW9 Chennaya Hiremat, he held the inquest Panchanama on the following day of the incident. Spot Panchanama on the following day of the incident.
Inquest or spot?
Spot Panchanama. Well, I'm anxious to mention before my lord,
This
crime was registered in crime number 330 of 2009 at 7 p.m. as I submitted
Hmm.
on 14/12/2009. The jurisdictional magistrate court is hardly at a distance of 1.5 kilometer from there.
Yes.
But FIR would reach the Honorable Court on the following day at 9:30 a.m. The FIR carrying police officer or FIR carrying police constable has not been examined in order to prove of the belated delay occurring in reaching of the FIR.
ಇದರಲ್ಲಿ ಅಪೋಸಿಟ್ ಯಾರು?
Incident
1 minute. ಯಾರು ಇದರಲ್ಲಿ? ಇದಲ್ಲ. Okay. Yes. It's all. Yes.
Incident took place on 14/12/2009 at 12:30 p.m.
Hmm.
in a place called
ಬನ್ನಿ ಮರದ ಕಟ್ಟೆ.
ಬನ್ನಿ ಮರದ ಕಟ್ಟೆ.
ತುಮಕೂರು
ಬನ್ನಿ ಮರದ ಕಟ್ಟೆ,
ತುಮಕೂರು
ಕುಣಿಗಲ್ ತಾಲೂಕ್, ತುಮಕೂರು ಡಿಸ್ಟ್ರಿಕ್ಟ್. Exhibit P, complaint. Yes. Complaint. Exhibit P. Yes. Your Honor, my lord finds the complaint starting from page 5. My lord,
Yes.
my lord, I would like to mention the motive part of the case. Yes.
Yes.
My lord, the complainant was said to have been allotted a site in Banni Maradakatte in the year 1985, bearing number 13 of 60/40 of the dimension of 60/40 by the government.
To whom?
PW1's husband.
Yes.
Husband, Mutturayappa. Mutturayappa is alive. In fact, as on the date of incident, he was in the hut. Now, my lord, this place was being claimed by accused number 1 as belonging to him, as having been allotted in his name. My lord, he was claiming it as belonging to him, also saying in the same breath that the complainant had been allotted the site in survey number 81.
So there is a rival claim.
Yes. Now, he had been allotted in site number. He was often going, according to them, according to the complainant, accused number 1 was often going with the members of his gang and picking up quarrels with PW1, asking her to quit the place with her inmates.
Yes.
Well, it was not of a few weeks or months. Her case is this had been going on for 3 years.
Yes.
Prior to 14/12/2009, for 3 years, often he was going and picking up cards. He was earlier a local panchayat member. He was earlier a district panchayat member also, accused number 1. PW3, brother-in-law of PW1, had contested the election against accused number 1. And they were not seeing eye to eye. They had become sworn enemies too. This is borne out by record. But I seek my lord's kind indulgence to permit me to read the complaint, which is starting from page 5. ವಿಷಯ ನಮ್ಮ ಮನೆಗೆ ಬೆಂಕಿ ಹಚ್ಚಿರುವ ಬಗ್ಗೆ ತಮ್ಮಲ್ಲಿ ಕೇಳಿಕೊಳ್ಳುವುದೇನೆಂದರೆ, ಮೇಲ್ಕಂಡ ಗೌರವನಾದ ನಾನು ಕೆಳವರ ಜಾತಿಗೆ ಸೇರಿದ್ದು, ನನ್ನ ಗಂಡನಾದ ಮುತ್ತರಾಯಪ್ಪನಿಗೆ ಲಕ್ವ ಹೊಡೆದು ಮಾತು ಬಾರದೆ ಹಾಗೆ ಆಗಿದೆ. ಪೇಜ್ 5 ಸ್ವಾಮಿ. ನಾನು, ನನ್ನ ಮಗ ಹಾಗೂ ಗಂಡ, ನನ್ನ ಅತ್ತೆ ಬನ್ನಿಮರದಕಟ್ಟೆ ಗ್ರಾಮದಲ್ಲಿ ನಿವೇಶನದ ಸಂಖ್ಯೆ 13ರಲ್ಲಿ ಸುಮಾರು 20 ವರ್ಷಗಳಿಂದ ವಾಸವಾಗಿದ್ದು ಯಾವುದೇ ರೀತಿಯ ಸಮಸ್ಯೆ ಇರುವುದಿಲ್ಲ. ಈಗ 3 ವರ್ಷಗಳಿಂದ ನಾವು ವಾಸಿಸುವ ಜಾಗ ಅಂದರೆ ಹಾಲಿ ಗುಡಿಸಲು ಇರುವ ಜಾಗ ನನಗೆ ಬರಬೇಕು ಎಂದು ಜಿಲ್ಲಾ ಪಂಚಾಯತ್ ಸದಸ್ಯ ಸೀತಾರಾಮಯ್ಯ ಅಕ್ಯೂಸ್ ನಂಬರ್ 1 ಎಂಬುವರು ಆಗಾಗ ಬಂದು ಜಗಳ ನಡೆಸುತ್ತಿದ್ದರು. ಈ ಬಗ್ಗೆ ಹಲವಾರು ಬಾರಿ ನಾವು ಠಾಣೆಯ ಮೆಟ್ಟಿಲು ಹತ್ತಿದ್ದು, ನಿವೇಶನದ ಪರವಾಗಿ ನ್ಯಾಯಾಲಯದ ಮೆಟ್ಟಿಲು ಹತ್ತಿರುವುದು ಆಗಿದೆ. ಆದರೂ ಬೇತಾಳದಂತೆ ಬೆನ್ನು ಬಿಡದೆ ಶಿವರಾಮಯ್ಯ ಬಂದು ಪದೇ ಪದೇ ಜಗಳ ಮಾಡಿ, ಗುಂಪು ಕಟ್ಟಿಕೊಂಡು ಬಂದು ಜಗಳ ಮಾಡಿ ಬೆದರಿಕೆ ಸಹ ಹಾಕಿ ಹೋಗುತ್ತಿದ್ದನು. ನಾವುಗಳು ಎಳವರಾಗಿದ್ದು ನಮಗೆ ಜನ ಬೆಂಬಲವಿಲ್ಲದೆ ನಾವು ಜೀವಭಯದಿಂದ ನರಳುವಂತಾಗುತ್ತಿತ್ತು. ಶಿವರಾಮಯ್ಯ ಮಾಜಿ ಜಿಲ್ಲಾ ಪಂಚಾಯತ್ ಸದಸ್ಯನಾಗಿದ್ದು ಹಲವಾರು ಜನರನ್ನು ಕರೆದುಕೊಂಡು ಬಂದು ಆಗಾಗ ಜಗಳ ಮಾಡುತ್ತಿದ್ದನು. ದಿನಾಂಕ 14/12/2009 ಸೋಮವಾರ ಮಧ್ಯಾಹ್ನ ಸುಮಾರು 12:30 ಸಮಯದಲ್ಲಿ ನಮ್ಮ ಪಂಚಾಯತಿಯ ಕಾರ್ಯದರ್ಶಿಯಾದ ಶಿವಕುಮಾರ್ ಮತ್ತು ಶ್ರೀಕುಮಾರ್, he was made accused number 2. Bill collector Shivanna, no accused. He has not been made accused. Shivramaya, accused number 1. Then Sadhya Kumaraya, no accused. Shane Gowda, accused number 3. Koppalbariyalli Adhyaksha Giri A4. Meghalapalya Betta Swamaya A6. Spasta. Ravi A5. Muddalingayana Maga ಶಾಂಪುರ ಹಾಗೂ ಶಾಂಪುರ, ನೋ ಅಕ್ಯೂಸ್ಡ್. ಇತರರು ಅವರ ಹೆಸರುಗಳು ನಮಗೆ ಗೊತ್ತಿಲ್ಲ. she would state of so many names as being troublesome people on that day. But Kumaraya, collector Shivanna, Kumaraya, Shampura have not been made accused.
But they are the accused in the FIR.
In the FIR, they have not been made accused. In the FIR only Shivaramaya, Kumar, Shanegoda, Giri, Ravi, Betta Swamaya are made accused. The rest are not made accused.
Who are left?
Shivaramaya A1, Kumar A2, Shane, my lord finds at page 2. Page 2. Then Shane Gowda A3, Giri A4,
Yes, I have found
Ravi
that.
A5, 6.
Who is left out?
Who have not been made accused are,
Who is left out?
firstly, bill collector Shivanna. Page 5, Swami, at the bottom.
Then
Bill collector Shivanna is mentioned as accused. Then page 6, Shampura. Muddalingay Namaga Shampura. First line at page 6. He has not been made accused. With the mentioning of name of last Muddalingaya Namaga Shampura, page 6, first line. He has also not been made accused. Well, I was the person who registered the crime, able to take a decision as to drop them from the list of accused without making any inquiry is an enigma. Then my lord, ಮುದ್ದಲಿಂಗೆ ನಮಗ ಶಾಂಪುರ ಮತ್ತು ಇತರರು ಅವರ ಹೆಸರು ನನಗೆ ಗೊತ್ತಿಲ್ಲ. Well, complainant definitely says many more persons having participated in committing of the offences as alleged. Investigating officer would take no pains in discovering the participation of those persons or discovering the names of those persons.
Yes.
The complainant, well, inner evidence would state 25 persons having come there in order to commit the offense. 25 persons. Yes. ಗೊತ್ತಿಲ್ಲ. It is also made known in the complaint. ಇತರರ ಹೆಸರುಗಳು ನಮಗೆ ಗೊತ್ತಿಲ್ಲ. ಸುಮಾರು 25 ಜನರು ಏಕಾಏಕಿ ನಮ್ಮ ಮನೆ ಹತ್ತಿರ ಬಂದು ಗಲಾಟೆ ಮಾಡಲು ಶುರು ಮಾಡಿದರು. ಅವಾಗ ನಾನು ಗೌರಮ್ಮ ನನ್ನ ಮಗ ಇದ್ದೆವು. ಇವರ ಗಲಾಟೆಯನ್ನು ನನ್ನ ಮೈದನನಾದ ಮಲ್ಲಿ ನಾನು ಓಡಿ ಬಂದನು. ನಾವು ಗ್ರಾಮದ ಪಂಚಾಯತಿ ಕಾರ್ಯದರ್ಶಿ ಕುಮಾರ್ ಅವರ ಹತ್ತಿರ ಈ ವಿಚಾರವಾಗಿ ವಾಗ್ವಾದ ನಡೆಸುತ್ತಿದ್ದ ವೇಳೆ this accused number 4 had been deputed, is a government official, accused number 4. He had been deputed by his superiors to go over to that place in order to take measurements of the sites and to find out of certain things. Therefore, he went there with another official who is CW6. He has not been examined. He is also an eyewitness to the occurrence and an independent person. CW6,
CW4.
PW4 and CW6 went at the instance of their superiors as government officials to the heart of PW1 to conduct an inquiry and to take measurements of the sites.
That is your defense.
Yes.
That is your defense.
Pardon me.
That is our defense. Your defense is it?
That is not only my defense. My further defense is that none of us set fire. None of the accused set fire to the hut. In particular, what is stated against accused number 1 inner evidence, my lord, my lord would find no reference to A1 having set fire to the hut is made in the complaint. No reference. I shall read the complaint full well. ನನ್ನ ಮಗ ಇದ್ದೆವು. ಕುಮಾರ ಹತ್ತಿರ ನಾವು ವಿಚಾರ ವಾಗ್ವಾದ ನಡೆಸುವ ವೇಳೆಯಲ್ಲಿ ಶಿವರಾಮಯ್ಯ A1, ಕುಮಾರ A2, ಶಾನೇಗೌಡ A3, ಗಿರಿ A4, ರವಿ A5, ಬೆಟ್ಸ್ವಾಮಯ್ಯ ಎಂಬುವರು ನನ್ನನ್ನ ಬಿಗಿಯಾಗಿ ಹಿಡಿದುಕೊಂಡರು. These 6 persons were said to have held PW1 tight. They held her. ಹಿಡಿದುಕೊಂಡರು. ಆಗ ಯಾರು ಎಂದು ಗೊತ್ತಿಲ್ಲ, ಶಿವರಾಮ್ ಕಡೆಯವರೇ ನಮ್ಮ ಮನೆಗೆ ಬೆಂಕಿ ಹಚ್ಚಿದರು. This makes clear. Shivaramaya was one of the persons who was holding her back. And somebody at that point of time, when she was being held by 6 persons, all these 6 accused persons, somebody set fire to her hut.
Yes.
And she did not know of who it was. She makes it further clear. Aga yaru endu gottilla. I did not know of that. I did not know who set fire to my hut. ಆಗ ಸುಮಾರು 12:30 ನಾವು ಗಾಬರಿಯಿಂದ ನಮ್ಮ ಮನೆಗೆ ಬೆಂಕಿ ಬಿದ್ದಿತ್ತು ಎಂದು ಬಾಯಿ ಬಡಿದುಕೊಂಡು ನಮ್ಮ ಅತ್ತೆಯವರನ್ನು ಸಾಧ್ಯವಾದ ಸಾಮಗ್ರಿಗಳನ್ನು ಎಳೆದು ತರುವಲ್ಲಿ ನಮ್ಮ ಮನೆ ಬೆಂಕಿಗೆ ಸಂಪೂರ್ಣ ಆಹುತಿಯಾಯಿತು. 1 ಗಂಟೆ ಸುಮಾರಿಗೆ ಬೆಂಕಿ ಆರಿಸುವ ವಾಹನ ಬಂದು ಬೆಂಕಿಯನ್ನು ನಂದಿಸಿತು. ಇದರಿಂದ ನಮ್ಮ ಮನೆಗೆ ಬೇಕಾಗಿದ್ದ ದಾಖಲೆಗಳು ಮತ್ತು ಸಾಮಾನುಗಳು ಸುಟ್ಟು ಹೋದವು. ನಾವು ಬೀದಿ ಪಾಲಾಗಿದ್ದೇವೆ. ದಯಮಾಡಿ ತಮ್ಮಲ್ಲಿ ಕನಿಕರವೆಂಬುದು ಇದ್ದರೆ, ನಮ್ಮಂತ ನಿರ್ಗತಿಕರಿಗೆ ಸಹಾಯ ಮಾಡುವ ಮನಸ್ಸು ಇದ್ದರೆ ತಾವು ಶಿವರಾಮಯ್ಯ ಮತ್ತೆ ಅವರ ಕಡೆಯನ್ನು ದಸ್ತಗಿರಿ ಮಾಡಿ ನಮಗೆ ನ್ಯಾಯ ಕೊಡಿಸಿ. This is the complaint. Well, this complaint was received by PW6. I would like to take my law to the evidence of PW6, page 55.
Why PW6?
Yeah. Page 55, Swami Sri Rangaya.
Why firstly you are taking through the evidence of PW6?
I can't. Why is evidence? Why is evidence?
Because, my lord, by that time she carried complaint to PW6. PW6 was in the police station. He was SHO and she went there. When she, her son and PW3, all of them, about 3 persons went there. My lord, they carried a written complaint. He received it. By then, PW, the fire extinguisher, PW Timapa, PW5 Timapa was already in receipt of receipt of information of the incident by the police.
Yes.
How did police come to know of it even before this lady went over there with a prepared complaint? And if this police officer had known of it, what was the message he received, or what was the information as to the incident he had received by then? Did he make a note of it in the SHD? Did he disclose the cognizable offense against anybody, including of these accused or excluding of these accused persons? That has been suppressed. In order to demonstrate of that in the context, I'm seeking my lord's permission.
There is no such cross-examination to PW6.
ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಇಲ್ಲ ಸ್ವಾಮಿ,
ಅದನ್ನೇ ಹೇಳ್ತಾ ಇದ್ದೀನಿ.
ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಇಲ್ಲ, ಆದರೆ it is possible for
It's different. It's different. Why there is no cross?
Inferential submission I am making. It is quite possible to infer of what I am now submitting before my lord, even though there is no cross examination. May I read this evidence, Swami?
Not necessarily. I have gone through that.
Yes. Now, last para, I may kindly be permitted to read in the cross examination, last part of PW6 cross examination, last part, Swami. 15/12/2009 ಬೆಳಗ್ಗೆ 9:15 ಗಂಟೆಗೆ ಸಿಬ್ಬಂದಿ ಕೈಗೆ ಕೊಟ್ಟೆ ಎಂದು ನಿಮ್ಮ ಸಲಹೆ ಸರಿಯಲ್ಲ. ಫಿರ್ಯಾದುದಾರರೇ ಠಾಣೆಗೆ ಬಂದು ಫಿರ್ಯಾದನ್ನು ತಯಾರು ಮಾಡಿಕೊಂಡು ಬಂದಿದ್ದರು ಎನ್ನುವುದು ನಿಜ. ಆದರೆ ಪ್ಯಾರಾದಲ್ಲಿ ಎಕ್ಸಿಬಿಟ್ ಫಿರ್ಯಾದಲ್ಲಿ ಶಿವರಾಮಯ್ಯನ ಕಡೆಯವರು ನನ್ನ ಮನೆಗೆ ಬೆಂಕಿ ಹಚ್ಚಿದರು ಎಂದು ಬರೆಯಲಾಗಿದೆ ಎನ್ನುವುದು ನಿಜ. So the defense took the stand that the complaint was prepared, exhibit P1 was prepared somewhere between 8 and 9 a.m. of the following day. 8 a.m. and 9 a.m. of 15/12/2009. Not at 7, he did not receive it at 7 p.m. of the previous day.
Yes.
There is not. PW1 to 4 are the eyewitnesses. PW1 to 4 are the eyewitnesses to the occurrence.
Yes.
161 statements of all these 4 witnesses from the time of complaint, receiving of complaint or lodging of complaint on 14, according to them, 14/12/2009. Well, statements of all these 4 eyewitnesses have been recorded on 22/1/2010. After more than a month, after 40 days, their statements have been recorded by the investigator. Well, at 436, had been alleged. It is needless for me to submit. It was the offense punishable under section, punishable with imprisonment for life. A serious offense. And well, it is offense punishable, not only punishable with imprisonment for life. PSI had no power, no authority, or he was incompetent to investigate into this. Immediately after the crime was registered, circle inspectors police would become competent to investigate into this. He would not, he would come on the scene as third investigator. After PW6, investigation would be taken over by PSI, who was incompetent to investigate into 436. All these things are.
He has only drawn the spot Panchanama.
Part Panchanama, yes.
No other investigation was
But,
done.
yeah. Well, at part, ಇದು PI ಗೊತ್ತಿಲ್ಲ. PF madam ಕಡೆ ಇರಬೇಕು. No, spot master was held on the following day, 15/12/2009, between 9 a.m. and 9:45 a.m. Well, with my lord's kind permission, I would like to submit, during this part mahza, if an eyewitness keep himself or herself present and make statement, and the same investigating officer cares to include in the Panchanama or in the mahzar, that can be read in evidence. PW1 was present. PW1 would put her LTM besides a pancha. Well, now the LTM of PW1 has not been identified by anybody. There is just an LTM found, not identified by anybody. But she would make a statement saying at page 7, Swami, Your Lordship kindly.
How much time you may require? Afternoon, Madhyana.
Monday.
Madhyana. Continue ಮಾಡಬೇಡಿ so that
I'm before my lord, I'm more than prepared to go on.
Yes.
I will go on because
It's
your
better.
lordship was mentioning to some other advocate to be here at 2:30.
ಮಾಡ್ತೀನಿ after your man. ಇದಾದ್ಮೇಲೆ Here they need it. 21 and 22.
Admission serial number 21, RB Deshpande.
Take notice. Additional SPP takes notice for respondent. Private issue notice.
14A2 of SC/ST.
Yes,
Original
notice.
complainant made as a party.
Notice.
Please, madam, please.
22, Srinivasa C.
In this matter, my lord, there is an atrocity.
I'll take up at 2:30.
Please, my lord. There is in charge sheet also 5.
Sir.
ಅದಕ್ಕೆ ರಿಕ್ವೆಸ್ಟ್ ಹಾಕಿಲ್ಲ ನಾನು ಬರೀ ಡೇಟ್ಸ್ ಹಾಕಿದ್ದೀನಿ ಕಳ್ಸ್ಬಿಟ್ರಾ ಸರಿ ಮಾಡಿದ್ದೀನಿ ಆಯ್ತಾ ಚಟ್ನಿ ಸರಿ ಹೋಯ್ತಾ ಚಟ್ನಿ ಸರಿ ಹೋಯ್ತಾ ಇವತ್ತು ನಿಮಗೆ ಸಾಯಂಕಾಲ ಮಿಸ್ ಮಾಡಬೇಡಿ ಬೇಗ ಬನ್ನಿ ನನಗೆ ಬೇಕಾಗಲ್ಲ ಇಲ್ಲಾಂದ್ರೆ ನಾನು ಬಿಟ್ಟರೆ ಇಲ್ಲೇ ಮಾಡ್ಕೊಂಡಿಲ್ಲ ಮನೆಗೆ ಬರೋದು ಆಮೇಲೆ ನೀನು ಬೇಡ ನೀವೇ ಸಿಗ್ಬೇಕು ನೀವು ಬೇಗ ಬಂದ ನೀವೇ ತಿಂದು ತಿಂದ್ಬಿಟ್ಟು ನಾನು ನೋಡ್ಕೊಳ್ತೀನಿ
ಗೊತ್ತೇ ಆಗಿಲ್ಲ ಬೆಳಗ್ಗೆ. ಸ್ವಲ್ಪ ಪರವಾಗಿಲ್ಲ ಗೊತ್ತಾಗ್ತಾರೆ ಇಪ್ಪತ್ತನೇ ಗೊತ್ತಾ ಇಲ್ಲ. ಆಮೇಲೆ ಮೈನರ್ ಪಾಸ್ವರ್ಡ್ಸ್ ಆಮೇಲೆ ಪಾಸ್ವರ್ಡ್ ತಗೊಂತಾರೆ. ಅದು ಅಪೆಲ್ ನಂಬರ್ 1 to 5 ಅಂತಾರೆ. ಅದು ಇರೋದೇ 1 to 5 NOC ತಗೊಂಡಿರೋದು. ಅದೇನು ಮಾಡ್ತಾರ ಅಂತ ಅಪೆಲ್ ನಂಬರ್ 6 ಇದ್ದಾನೆ. ಬಟ್ ಅದೇ ಅಪೆಲೆಂಟ್ ಸರಿ ಬಂದು ಇವರು 5 ನೋಡ್ಕೊಂಡು ಅಪೆಲೆಂಟ್ ಸರಿ ಅಂತ ಮಾಡಿ ಮತ್ತೆ ಒಂದು ಸುಮ್ಮನೆ ಮಿಸ್ಟೇಕ್ ಮಾಡ್ತಾರೆ. ನಾವು ಅನುಸರಿಸ್ಕೊಂಡು ಹೋಗಿಲ್ಲ. ಆಮೇಲೆ ಇಶ್ಯೂ ಮಾಡ್ತಾ ಇದ್ದೀವಿ. ಅದಕ್ಕೆ ಈ ಸತಿ ಕೇಳ್ತೀವಿ ಯಾರ ಅಪೇರೆನ್ಸ್ ಹೇಳ್ಕೊಂಡು ಬಂದಿದ್ದಾನೆ ಮೇಡಮ್ ಅಂತ ನಾನು ಟಿಕ್ ಆಗ್ತಾ ಇದ್ದೀನಿ. ಇವಾಗ ಇವ್ರಿಗೆ ಆರ್ಗ್ಯೂ ಮಾಡಿದ್ರೆ ನಾನು ಟಿಕ್ ಮಾಡ್ಕೊಂತೀನಿ. ಅದನ್ನೇ ನಾನು ಮಾಡ್ತಾ ಇಲ್ಲ, ಅವರಿಬ್ರು ಸೇರ್ಕೊಂಡು ಮಾಡ್ಬೇಕು. ಜೋರು ಹೊಡೆದಿದ್ದವ್ರೆ. ನಾನು ಅದಕ್ಕೆ ರವಿಗೆ ಏನು ಗೊತ್ತಿಲ್ಲ ಇದನ್ನೇ ಕೇಳಿಸ್ಬೇಕು. ಡೇಟ್ ಮಿಸ್ ಆಗಿದೆ ಅವನು ನಾನು ಕೇಳ್ತೇನೆ. ಡೇಟ್ ಮಿಸ್ ಆಗಿದೆ ನೋಡಿ ಸರಿ ಮಾಡಿ ಯಾರ ಥರ ಕೇಳ್ತಾರಲ್ಲ ಯಾರಿಗೂ ಈಗ ಇವರು ಲತೀಫ್ ಇವತ್ತು ಡೇಟ್ ಇದೆ ಅಂತ ಬಂದಿಲ್ಲ. ಬಿಟ್ಬಿಡ್ತೀನಿ ಹಂಗೇನು ತಕ್ಷಣ ಆದರೆ ಮಾಡ್ಬೋದು. ಬಿಟ್ಟು ಬಿಟ್ಟು ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಅಂದ್ರೆ ನಾವೇನು ಮಾಡೋಣ. ಅವರು ಹೇಳೋದು ನೀವು ಆಮೇಲೆ ಬರೀತೀರ ಅನ್ಸುತ್ತೆ ಡೇಟು. ನಾನು ಆಮೇಲೆ ಬರೆಯೋ ಪ್ರಶ್ನೆನೇ ಬರ್ತಾ ಇಲ್ಲ. ಚೇಂಜೇ ಆಗ್ತಾ ಇಲ್ಲ. ಈರೋಷ್ಟು ಏನಂತ ಅರ್ಜೆಂಟ್ ಏನಿಲ್ಲ. ಇದು ಈಸಿ ಆಗೋದ್ರಿಂದ ತಕ್ಷಣ ಮಾಡ್ಬೋದು. ಹೀಗೆ ಸಬ್ಮಿಟಲ್ಲಿ ಇರೋದ್ರಾಗ ಒಂದೇ ಸತಿ ಆಗಲಿಲ್ಲ ಆಗೋದಿಲ್ಲ. ಅವಾಗ ತಕ್ಷಣ ಕೊಡೋಕ್ಕಾಗ್ತದೆ. ಆಮೇಲೆ ಫೋನ್ ಮಾಡಿದ್ದೀವಿ ಎಷ್ಟು ಸತಿ ಸ್ಲಿಪ್ ಅಂಡ್ ಕಳಿಸಿದ್ದೀವಿ. ಏನೋ ಮಾಡ್ಕೊಳ್ಳಿ ಅದು ಕೇಸು ನಾಳೆ ತಿಂಗಳು ಹೇಳೋದೇನು ಅಂತ ಫಿಕ್ಸ್ ಆಗ್ಬಿಟ್ಟಿದ್ದಾರೆ ಅನ್ಸುತ್ತೆ. ಕೇಳಿಸಲ್ಲ ಯಾರು ಬಂದು ನನಗೆ ಹೇಳಿದ್ರು ನಾವು ಅಲ್ಲೇ ಸುಭಾಷ್ ಅವ್ರಿಗೆ ಅದಕ್ಕೆ ನಾವು ಹೇಳ್ತಿದ್ದೀವಿ. ಹಂಗಂತ ನಮ್ಮಲ್ಲಿ ನೋಡಿದ್ರೆ ನನ್ನ ಹತ್ರ ಕೇಳ್ತಾರೆ. ಬೇಸಿಕಲಿ ಜೋರಾಗೆ ಮಾತಾಡೋದು. ಹೇಳಿಲ್ವಾ ಅವ್ರಿಗೆ ಫೈಲ್ಸ್ ರಿಕಾರ್ಡ್ಸ್ ಎಲ್ಲ ಬರ್ತಾಯಿಲ್ಲ ಈ ಸಲ ಹೇಳಿಲ್ವಾ ಎಲ್ಲ ತೆಗೆದುಕೊಂಡು ನಾವು ಏನು ಅರ್ಥ ಮಾಡ್ತೀವಿ ಟೈಮ್ ಕರೆಕ್ಟಾಗಿ ವಾಯ್ಸ್ ಜೋರಾಗಿರ್ಬೇಕು ಹಿಂಸೆ ಕೊಡ್ತಾರೆ ಇವಾಗಂದ್ರೆ ವಾಯ್ಸ್ ಜೋರಾಗಿರ್ಬೇಕು. Serial number 22, Srinivas C.
Pursuant to the interim order, my lord, the charge sheet is filed.
Petition appellant, sir, accused number 1 and 2.
My lord, accused number 1, 2, 3, my lord. After investigation, my lord, accused number 3 is dropped in the charge sheet, my lord.
Accused number?
Accused number 3 is concerned, my lord. The investigation officer is dropped the.
While filing charge sheet.
Please, my lord.
Yes. What are the offence alleged?
My lord, offence under section 352, 351, 315, class 2, 35 BNSS, and 75J, JJ Act, my lord, and Atrocity Act 31 RS, my lord. The charge sheet, my lord, permit me to place the charge sheet, my lord.
Let's read column number 17.
My lord. Column number 17, page number 9 in the ದೋಷಾರೋಪಣಾ ಪಟ್ಟಿ ಕಾಲಂ 12 ರಲ್ಲಿ ಸೋನ್ಸೋ ಕೆಳಗಡೆ ಸಾಕ್ಷಿ ಇವರು ಮೇಲ್ಕಂಡ ವಿಳಾಸದ ಬಾಡಿಗೆ ಮನೆಗೆ ಬಂದ ನಂತರ ಈ ಕೇಸಿನ A1 ಆರೋಪಿಯು ಸಾಕ್ಷಿ 1 ಅವರ
They are the neighbors.
ನೇಬರ್ಸ್
Yes.
ಅವರು ಪರಿಶಿಷ್ಟ ಜಾತಿ ಆದಿ ಕರ್ನಾಟಕ ಜನಾಂಗದ ಸೇರಿದವರಾಗಿರುತ್ತಾರೆಂಬುದು ವಿಷಯವನ್ನು ತಿಳಿದುಕೊಂಡು ಸಾಕ್ಷಿ 1 ಅವರು ಕುರಿತು ಪ್ಯಾಸೇಜ್ ಜಾಗದಲ್ಲಿ ಇಟ್ಟಿರುವ ತುಳಸಿ ಗಿಡವನ್ನು ಟಚ್ ಮಾಡಿಕೊಂಡು ಓಡಾಡಬೇಡಿ, ಮನೆ ಮುಂದೆ ನೀರು ಹಾಕಬೇಡಿ, ಮನೆಯಲ್ಲಿ ಮಾಂಸವನ್ನು ಮಾಡುತ್ತೀರಿ, ಇದು ನಮ್ಮ ಜನಾಂಗಕ್ಕೆ ಆಗಿ ಬರುವುದಿಲ್ಲ. ಈ ಕಾರಣ ಬಾಗಿಲನ್ನು ತೊಳೆಯುವಾಗ ನೀರು ನಮ್ಮ ಮನೆ ಬಾಗಿಲು ಕಡೆ ಚೆಲ್ಲಬೇಡಿ, ಮಕ್ಕಳು ಮತ್ತು ಮನೆಯ ಕಡೆ ಬಿಡಬೇಡಿ ಎಂದು ಸಣ್ಣ ಪುಟ್ಟ ವಿಷಯಗಳ ಕಿರಿಕಿರಿ ಮಾಡುತ್ತಿದ್ದು, ಇದರಿಂದ ಇಬ್ಬರೂ ನಡುವೆ ವೈಮನಸ್ಸು ಉಂಟಾಗಿರುತ್ತದೆ. ಮುಂದುವರಿದು ಈಗ 6 ತಿಂಗಳ ಹಿಂದೆ ಒಂದು ದಿನ ಮಧ್ಯಾಹ್ನ ಸಾಕ್ಷಿ 1 ಅವರ 2 ವರ್ಷದ ಮಗು ಕುಶಾಲ್ ಈತನು ಆರೋಪಿಗಳ ಮನೆಯ ಮುಂದಿನ ಪ್ಯಾಸೇಜ್ ಜಾಗದಲ್ಲಿ ಮೂತ್ರ ವಿಸರ್ಜನೆ ಮಾಡುತ್ತಾರೆಂಬುದು ಕಾರಣದಿಂದ A1 ಆರೋಪಿಯು ಕೋಪಗೊಂಡು ಸಾಕ್ಷಿ 1 ಅವರ ಮಗ ಕುಶಾಲ್ ಈತನ ತಲೆ ಮೇಲೆ ಕೈಯಿಂದ ಹಲ್ಲೆ ಮಾಡಿದ್ದಲ್ಲದೆ ಇದನ್ನು ಪ್ರಶ್ನಿಸಿದ ಸಾಕ್ಷಿ 1 ರವರು ಕುರಿತು ನೀವು ಕೆಳ ಜಾತಿಯ ವಲಯ ಸೋನ್ಸೋ ಮಾದಿಗರು, ನೀವು ನಿಮ್ಮ ಮಗ ಕಂಡು ಸೋನ್ಸೋ ಮೂತ್ರ ಮಾಡುತ್ತಿರುತ್ತಾರೆ, ಇದರಿಂದ ನಾವು ಹೇಗೆ ಓಡಾಡಬೇಕು, ಮನೆಯ ಮಾಲೀಕರಿಗೆ ಹೇಳಿ ಮನೆಯನ್ನು ಖಾಲಿ ಮಾಡಿಸುತ್ತೇವೆ ಎಂದು ಬೆದರಿಕೆ ಹಾಕಿ ಜಾತಿ ನಿಂದನೆ ಮಾಡಿರುತ್ತಾರೆ. ಈಗಿರುವಾಗಲೇ ಅಂದರೆ ದಿನಾಂಕ 30/10/2024 ರಾತ್ರಿ 8 ಗಂಟೆಯ ಸಮಯದಲ್ಲಿ ಕಟ್ಟಡದ ನೀರನ್ನು ಮೋಟಾರ್ ಆನ್ ಮಾಡಿರುವ ವಿಷಯವಾಗಿ A1 ಆರೋಪಿಯು ಸಾಕ್ಷಿ 1 ಮೇಲೆ ಜಗಳ ತೆಗೆದು ಅವರನ್ನು ಕುರಿತು ಟ್ಯಾಂಕ್ ತುಂಬಿದ ಮೇಲೆ ವಾಟರ್ ಆಫ್ ಮಾಡಬೇಕೆಂಬುದು ಗೊತ್ತಿಲ್ಲವಾ, ಕಚಡ ಮುಂಡೆ ನಿನಗೆ ಹೊಟ್ಟೆಗೆ ಏನು ತಿಂತೀಯ, ಜಾತಿಗೆಟ್ಟ ಮುಂಡೆ ಸೋನ್ಸೋ ಇದಲ್ಲದೆ ಹೇಳಿ ಅವಾಚ್ಯ ಶಬ್ದಗಳಿಂದ ಬೈದು ಜಾತಿ ನಿಂದನೆ ಮಾಡಿರುತ್ತಾರೆ. ಅಲ್ಲದೆ ದಿನಾಂಕ 2/12/2024 8 ಗಂಟೆ ಸಮಯದಲ್ಲಿ ಅವರು ಮನೆ ಬಾಗಿಲು ಕಡೆ ನೀರನ್ನು ಬಿಟ್ಟಿರುತ್ತಾರೆಂಬುದು ಕಾರಣದಿಂದ A1 ಆರೋಪಿಯು ಸಾಕ್ಷಿ 1 ಅವರ ಮೇಲೆ ನಿಮ್ಮ ಮನೆ ಕಡೆ ಹಾಕಿದ
Yes. Investigation completed. No criminal antecedents. Yes. Case number 1 and 2 in so seeking grant of bail. Affirmative for the following reasons. The informant lodged the first information against the accused for having committed the offence as stated above. They stated that about 6 months earlier to filing of the first information, accused number 1 had assaulted the son of CW1 and abused her in Hindu language by referring to her caste and humiliated her. On 30/10/2024, again, accused number 1 picked up quarrel. As the CW1 has spilled the water in front of the house of accused number 1. The investigation is completed, charge sheet is came to be filed. It is not the contention of the prosecution that the appellants are required for further investigation or for any reason except to ensure their presence before the trial court. It is also not the contention of the prosecution that the appellants are having any criminal antecedents. This court today order dated 2024 granted the ensuing bail to the appellants. There is no allegation that they have misused the liberty granted in their favor. Under such circumstances, I do not find any reason to reject the claim made by the promotion. Allowed subject to conditions.
Much.
Yes. Who corrected?
After matter, serial number 2, Utsav Gowda.
Hearing my lords for the petition.
There are no other documents?
Lords, only affidavit we have filed, my lords. Any other documents I'll have to verify, my lords.
Not yet verified?
It is that person only, my lords. If any,
I'm asking you, is there any document? That is why the matter was passed over.
Please, my lords.
Ah.
Only affidavit.
And still you are saying I will verify?
Only affidavit has been filed, my lords.
She is not Munnamma.
Lords, they refer to her as Munnamma, but she is saying as per Aadhaar card, her name is Yasmin Banu.
Her concept of the appellant on office objection at serial number 5. It is stated that as per the judgment, the appellant is referred to as Munnamma. However, it is stated that her real name is Yasmin Banu. In that regard, an affidavit is owned by the appellant. As we said, affidavit and the submission is accepted. Office objection at serial number 5 is ignored. What about Aliashtana Bandana? Issue notice to respondents.
Lords, filed suspension of sentence. My lords, they were out on bail, my lords, from 26/2013. Sorry, 26/12/2013. Offense is 326, my lord.
ಎಲ್ಲಿದೆ ಬೇಲ್ನಲ್ಲಿ ಇದ್ರು ಅಂತ?
Lords, it's as per the charge sheet, my lords, they say there have been 26/12/2013 ರಂದು ಆರೋಪಿತರು ಘನ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಹಾಜರಾಗಿ ಜಾಮೀನು ಪಡೆದುಕೊಂಡಿರುತ್ತಾರೆ.
Yes. Appellants were on bail during trial. Well, happy format happy. Allowed subject to conditions. Respondent number 2 an issue ಮಾಡಿ. Yes, allowed.
Obliged, my lords.
Serial number 4, Monica Patel.
For the appellant in this matter, my lord. My lord was passed over this morning to verify service, my lord.
So, HGP filed the police report of
If I may kindly be heard.
of notice to respondent number 2. Yes.
My lord, offences, section 69 is invoked, my lord, indicating.
Are 2 idara?
Please, my lord. Section 31R, 31S, intentionally insulting in public view, abusing in public view. 3 to 5, my lords, which is if an offense is punishable with 10 years imprisonment. 31W, touches without consent. 35, common intention. 669, sexual intercourse employing deceitful means, my lord, by promising to marry. Now, my lord, her allegation is that she's a side actress. He, my lord, has completed a course in electrician course, and he's a certified electrician who had come here from Chitradurga, 24-year-old boy, my lord, and she is older to him. She indicates that he promised to marry her. Both of them were in a relationship.
This appellant is 24 years.
24 years, my lord.
Victim is?
Victim is 26 years. I've produced photos also. She indicates that in the guise of promising to marry her, he took her to some OYO rooms and both were both indulged in some sexual activities. And she claims now he has refused to marry her. Hence, action should be taken against him.
Arrested?
May 1st, my lord. In fact, my lord, on arrest, he was directly sought to be remanded to the judicial custody. That is at page 24.
Charge sheet is filed?
Charge sheet is not filed, my lord.
Yes.
Since
You have not taken, is not required for custody. Huh? Stay. Affirmative for the following. Accused number 1 seeking grant of bail. Affirmative for the following reasons. The appellant, being accused number 1, was apprehended on 1/5/2025. Since then, he is in judicial custody. The informant, aged 26 years, has made allegations against the accused that he has committed various acts, including the sexual assault under promise to marry, and he humiliated her by referring to her caste in public. Admittedly, the appellant is not required for further investigation. He is also not required to be detained in custody for any other purpose except to ensure his presence before the trial court. It is not the contention of the prosecution that the appellant is having any criminal antecedents. Under such circumstances, his detention in custody would amount to so much. Allowed subject to conditions.
Serial number 16. Section कराया.
grateful, my lord.
Yes, my lord, I was about to draw my lord's kind attention to exhibit P5 at page 7.
No, what are grounds on which you are impugning the judgment?
My lord, grounds are PW 1 to 3 are from the same family. They are highly interested. Parties on witnesses. Inimical. Particularly PW 3. There were independent witnesses available. I demonstrate of the from page 8. I'm sorry, from spot measure. Yes, well, spot measure. ಚೆಕ್ಕುಬಂದಿ ಪೂರ್ವಕ್ಕೆ ಆನಂದನ ಪೆಟ್ಟಿಗೆ ಅಂಗಡಿ to the
ಆಯ್ತು ಆಮೇಲೆ
it was surrounded by also there were 50 houses in the locality. Evidence is there were 50 houses. None from those houses has been examined.
Yes.
But independent witnesses were available. Then PW5 is an independent witness. I'm sorry. 4. PW4 is an independent witness, official witness. He speaks to the incident. He gives us the vivid picture of the incident, but he has not been believed. An independent witness.
Whether PW4
PW4,
whether he was treated hostile? No.
He has partially been treated hostile. Only partially. He had gone there on that day on official duty.
What is the official duty?
PW4.
What is the official duty?
Official, he had to conduct inquiry there on that day. To survey, he had to prepare survey of the house of PW1
You know, what
on
is
the,
his
on the allegations of A1.
What is his designation?
Village Panchayat Secretary. He had gone with CW6, another official of the Panchayat department, CW6. Both of them were there. CW6 has not been examined in the court. We would have had first-hand knowledge of the incident better had he also been examined, since he is an independent witness. He has not been examined. Then my lord, when the spot mahazar was prepared, that case's complaint was given at 7 p.m. of the previous day. Had in reality, if the police officer had received the complaint, the next duty he was to perform was to detail 1 or 2 constables on special duty to guard the spot till the investigating officer went there the following day. When he went there at 9:30 a.m. of the following day, there was no police constable guarding the place of occurrence from the local police station or jurisdiction police station. This probabilizes the statement of the accused or the contention of the accused that during that night, at no point of time, complaint had been received by the local police. It was received only the following morning. Therefore, the FIR reached at 9:30 a.m., which is at a distance of 1.5 kilometers from the place of occurrence.
Yes.
Now, my lord, I have one more ground. My lord, I have a very strong ground to urge. That ground is further, the ground is in the complaint. There is, the complainant has not been able to name or identify the person who set fire to the hut. She was caught hold of by A1 with others when the fire was set to the hut. She has in particular stated having not known of the person setting fire to the hut.
Yes.
She in clear terms she said. Now she got the next opportunity to reiterate the same thing in the morning of next day. I shall before I make it a full-fledged ground, I would like to draw my lord's kind attention to a few contents of this part mahazar. The spot mahazar ali Swami, exhibit page 7 ali, the middle of page 7, spot mahazar. ಹೀಗೆ ಸುಮಾರು
Exhibit?
Page 7, Swami.
P5.
Exhibit P5 at page 7. From the middle, ಸುಮಾರು 3 ವರ್ಷಗಳಿಂದ
Yes.
ಸುಮಾರು 3 ವರ್ಷಗಳಿಂದ ಮಾಜಿ ಜಿಲ್ಲಾ ಪಂಚಾಯತಿ ಸದಸ್ಯರಾದ ನಾರ್ಜನಕುಪ್ಪೆ ವಾಸಿ ಶಿವರಾಮಯ್ಯ 2 kilometers ಫ್ರಮ್ ದೇರ್ ಎಂಬುವರು ಜನಗಳನ್ನು ಗುಂಪಿಟ್ಟುಕೊಂಡು ಬಂದು ಆಗಾಗ್ಗೆ ಗುಡಿಸಲು ಹಾಕಿರೋ ಜಾಗ ನನಗೆ ಸೇರಬೇಕೆಂದು ಗಲಾಟೆ ಮಾಡಿ ಹೋಗುತ್ತಿದ್ದರು. ಇಲ್ಲ, ಫರ್ದರ್ ಇದೆ ಸ್ವಾಮಿ, ಫರ್ದರ್ ಇದೆ. 14/12/9 ಸುಮಾರು 12:15 ಗಂಟೆಗೆ ಪಂಚಾಯತಿ ಕಾರ್ಯದರ್ಶಿ ಕುಮಾರ್, ಕಲೆಕ್ಟರ್ ಶಿವಣ್ಣ, ದೀಸ್ ಆರ್ ಅಫಿಷಿಯಲ್ ವಿಟ್ನೆಸಸ್ ಪರ್ಸನ್ಸ್. ಶಿವರಾಮಯ್ಯ ಅಕ್ಯೂಸ್, ಕುಮಾರ್ A2, ಬೆಟ್ಸ್ವಾಮಯ್ಯ A6, ರವಿ A5, ಗಿರಿ A4 ಹತ್ತಿರ ಬಂದು ನಮ್ಮೊಂದಿಗೆ ಜಗಳ ಮಾಡುತ್ತಿದ್ದರು. ಆಗ ನಾನು ಮತ್ತೆ ಗಂಡ ಮಕ್ಕಳು ಪಂಚಾಯತಿ ಕಾರ್ಯದರ್ಶಿ ಕುಮಾರ್ರೊಂದಿಗೆ ಈ ವಿಚಾರದಲ್ಲಿ ಮಾತನಾಡುತ್ತಿದ್ದಾಗ ಮೇಲ್ಕೊಂಡವರು ನಮ್ಮನ್ನು ಹಿಡಿದುಕೊಂಡಾಗ she repeats, she was caught hold of again. ಶಿವರಾಮಯ್ಯನ ಕಡೆಯವರು ನಮ್ಮ ಗುಡಿಸಲು ಮನೆಗೆ ಬೆಂಕಿಯನ್ನು ಇಟ್ಟರು.
That is what they stated in the first
She
information.
does in the complaint also.
That is what that extracted.
But my lord would be able to appreciate my argument when I take my lord to the evidence, I'm in chief of PW1. My lord, in chief, she makes mortal developments.
Yes.
She implicates accused number 1 in particular.
Directly come to the evidence.
ಯಾವ್ದು ಗೊತ್ತಿಲ್ಲ. ತಕ್ಷಣ ನಾನು ಇತರ ಮನೆಯೊಳಗೆ ಹೋಗಿ ಲಾಸ್ಟ್ ಪಾರ್ಟ್ ಸ್ವಾಮಿ, ಲಾಸ್ಟ್ ಪಾರ್ಟ್ ಮಾಜರಲ್ಲಿ ಲಾಸ್ಟ್ ಪ್ಯಾರಾದಲ್ಲಿ ಆನಂದ್ ಇಲ್ಲ ಪೆಟ್ಟಿಗೆ ಅಂಗಡಿ ತುಮಕೂರು ಮುದ್ರತೆ, ಪಶ್ಚಿಮಕ್ಕೆ ದೊಡ್ಡ ಪಾಪ ಎನ್ನುತ್ತದೆ, ಉತ್ತರಾದಿ ಬಾಪ್ತು ನಿವೇಶನ ಮತ್ತು ಚಿಕ್ಕದೇಕು ಓದಿಸ್ತೆ, ದಕ್ಷಿಣಕ್ಕೆ ಉತ್ತರಕ್ಕೆ ಪಿರಿಯಾದಿ ಬಾಪ್ತು ಖಾಲಿ ನಿವೇಶನ. ಅವ್ರ ಮನೆಯ ಉತ್ತರ ಭಾಗಕ್ಕೆ ಅವರದ್ದು ಖಾಲಿ ನಿವೇಶನ. 2 sites had not been allotted to them by the government. My lord, that one which was to the north of her was belonging to her in fact.
Yes.
Not the one she was asserting as belonging to her. Therefore, accused number 1 was always right in saying this hut was the site upon which hut had been built, pitch was not belonging to her. It was the site which was to the north of her hut that was belonging to her. He was right.
Yes.
Then, my lord, nextly, I would like to take my lord to the examination in chief of Gauramma PW1 for a moment.
Please do not read the entire evidence.
Yes.
Only relevant portion you highlight. Yes, I understood what you mean to say.
Yes. Relevant portion. Now, PW1, page 27 at the bottom. ನಮಗೆ ಬೇರೆ ಜಾಗ ಇಲ್ಲದೆ ಇರೋದ್ರಿಂದ ಹೀಗಾಗಿ ಪ್ರತಿ ವಾರವೂ ಸದಿರಿ ಶಿವರಾಮಯ್ಯ ಬಂದು ನಮಗೆ ತೊಂದರೆ ಕೊಡುತ್ತಿದ್ದರು. ಹಕ್ಕುಪತ್ರಗಳನ್ನು ನಮ್ಮ ಯಜಮಾನರು ಮಾಡಿಸಿಕೊಂಡಿದ್ದರು. ನಾವು ಸೋಗೆಗರಿಗಳನ್ನು ಹಾಕಿ ಗುಡಿಸಲು ಕಟ್ಟಿಕೊಂಡು ಇದ್ದೆವು. ಗುಡಿಸಿನಲ್ಲಿ ನಾನು, ನನ್ನ ಗಂಡ, ನನ್ನ ಮಗ ಮತ್ತು ನನ್ನ ಅತ್ತೆ ಇರುತ್ತಿದ್ದೆವು. ನಾವು ಮೇಲೆ two more persons. ಅತ್ತೆ, her mother-in-law has not been examined.
Yes.
Her husband has not been examined. Only son and herself have been examined. ಹೀಗೆ ಪ್ಯಾರಾ 3 2 ವರ್ಷಗಳ ಹಿಂದೆ ಮಧ್ಯಾಹ್ನ 12 ಗಂಟೆಗೆ ನಮ್ಮ ಗುಡಿಸಲಿಗೆ ನಾನು, ನನ್ನ ಅತ್ತೆ, ನನ್ನ ಮಗ ಮನೋಹರ ಇದ್ದೆವು. ಆಗ ಆರೋಪಿತ ಶಿವರಾಮಯ್ಯ ಗುಂಪು ಒಂದನ್ನು ಕಟ್ಟಿಕೊಂಡು ಬಂದು ಗುಡಿಸಲು ನಾವು ಖಾಲಿ ಮಾಡಿಕೊಂಡು ಹೋಗ್ಬೇಕು. ಬೆದರಿಸಿದ್ದಲ್ಲದೆ ಗುಡಿಸಲಿಗೆ ಬೆಂಕಿ ಹಚ್ಚಿದರು. ಹಾಗೆ ಬಂದ ಎಲ್ಲಾ ವ್ಯಕ್ತಿಗಳ ಹೆಸರು ನನಗೆ ಹೇಳಲಾಗುವುದಿಲ್ಲ. ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಆದಿರುವ ಆರೋಪಿಗಳು ಅವರಲ್ಲಿದ್ದರು. ಅವರು ಹಚ್ಚಿದಾಗ 12 ಗಂಟೆ ಆಗಿತ್ತು. ನನ್ನನ್ನು ಬೆಂಕಿ ಆರಿಸಲಾಗಲಿಲ್ಲ. ಹೊತ್ತಿವರದ ಬೆಂಕಿ ಅಗ್ನಿಶಾಮಕದವರು ಬಂದ್ರು. ಮನೆಯಲ್ಲಿ ಬಟ್ಟೆ, ಕಾಳು ಕಡ್ಡಿ, ಬೆಂಚು ಎಲ್ಲವನ್ನು ಬೆಂಕಿಯನ್ನು ಸುಟ್ಟು ಹೋದವು.
Come to the cross examination.
Nextly, cross examination. May pass for a while and submit. In the Mahazar exhibit P5, they have given the total cost of the property destroyed. They have set it at 12,000. 12,000 rupees worth of property had been destroyed,
Yes.
which was kept in the hut.
Yes.
Cross-examination for the first accused at page 29. PW4 Mallaya, PW3 Mallaya, ನನ್ನ ಗಂಡನ ತಮ್ಮನಾಗಿದ್ದು ಆತ ನಮ್ಮ ಊರಿನಲ್ಲಿ ಗ್ರಾಮದ ಪಂಚಾಯತಿಗೆ ಚುನಾವಣೆಗೆ ಸ್ಪರ್ಧಿಸಿದ್ದ ಎನ್ನುವುದು ನಿಜ. ಅವನಿಗೆ ಸದರಿ ನನ್ನ ಮೈದುನನಿಗೂ ಮತ್ತು 1ನೇ ಆರೋಪಿತನಿಗೂ ಮೊದಲಿಂದನೂ ರಾಜಕೀಯ ದ್ವೇಷವಿತ್ತು ಎಂದರೆ ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ಆ ರಾಜಕೀಯ ದ್ವೇಷದಿಂದ ನಾನು ನನ್ನ ಮೈದನಿಗೆ ಬೆಂಬಲ ನೀಡುತ್ತಿದ್ದೆ ಎನ್ನುವುದು ಸರಿಯಲ್ಲ. ಕಂಪ್ಲೇಂಟ್ ಬರವಣಿಗೆ ಪೊಲೀಸರು ಮಾಡಿರುತ್ತಾರೆ. Well, it is false. They went with a prepared complaint to the police station. Is the case of PW6. They went with a prepared complaint. Complaint ಅನ್ನ ನಾನು, ನನ್ನ ಮಕ್ಕಳು, ಮೈದುನ ಹೇಳಿ ಬರೆಸಿರುತ್ತೇವೆ. Malad, 3 persons put their heads together to prepare the complaint.
Yes.
It is the result of thoughts of 3 persons, thinking of 3 persons. No independent witness participated when the complaint came about. ಬರೆದ ವ್ಯಕ್ತಿಯ ಹೆಸರು ಅಥವಾ ಹುದ್ದೆ ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ಕಂಪ್ಲೇಂಟ್ ಏನು ಬರೆದಿದ್ದಾರೆ ಎಂದು ಓದಿ ಹೇಳಲಿಲ್ಲ. ಆದರೆ ನಮ್ಮ ಮಕ್ಕಳಿಗೆ ಸಾಕ್ಷ್ಯ ಸ್ವಚ್ಛಂದ ಹೇಳ್ತಾರೆ, ಬೆಂಕಿ ಇಡಲಿಲ್ಲ. ಬಂದವರೆಲ್ಲರೂ ನಾನು ಸುಳ್ಳೆ ಏಕೆ ಹೇಳಲಿದ್ದು ಬೆಂಕಿ ಇಟ್ಟದ್ದು ಶಿವರಾಮಯ್ಯ, ಬೆಂಕಿ ಇಟ್ಟದ್ದು ಶಿವರಾಮಯ್ಯ. She volunteered.
Shivaramaya is case number 1.
A1. Now, she, my lord, over and again in the complaint, she said, Shivaramaya having not set, I mean, the fire.
Yes.
Now, in the Mahadar also, which came to be prepared the following day, she got one more opportunity to tell the police officer of what happened when the incident took place. Then, for the second time also, she said Shivaramaya was not responsible for putting
Next
fire.
point, Bunny, I understood your point.
Now she volunteers.
Yes.
Now she volunteers said it is only Shivaramaya who set fire.
Correct.
My lord, this is what I submitted a moment back before my lord, saying this is a mortal improvement made by this witness in order to implicate with accused number 1 Shivaramaya.
Yes.
ನಿಮ್ಮ ಪಿರಿಯಾದಲ್ಲಿ ನೀವು ಶಿವರಾಮನ ಕಡೆಯವರು ಬೆಂಕಿ ಇಟ್ಟರು ಎಂದು ಹೇಳಿದ್ದೀರಿ, ಏನನ್ನುತ್ತೀರಿ? ಗಾಬರಿಯಲ್ಲೇ ಆಗಿಳಿರಬಹುದು, ಆದರೆ ಶಿವರಾಮಯ್ಯನವರೇ ಬೆಂಕಿ ಇಟ್ಟಿದ್ದಾರೆ, ನಾನು ನೋಡಿದ್ದೇನೆ. ಗಾಬರಿಯಲ್ಲಿ ಬಂತು ಸ್ವಾಮಿ. Even assuming complaint was given by her, as he has, said at 7 p.m. There was enough time. She was not enough time had lapsed. If it was following day, yes, whole of that they were sitting and brooding over implicating of persons. Even then they were not able to implicate Shivaramaya when the complaint was given. Now she says, now at this stage, Gabari, there could not have been any Gabari. She could never have been in shock because enough time had been had elapsed. ಅಗ್ನಿಶಾಮಕದವರ ಜೊತೆ ಪೊಲೀಸರು ಸಹ ಬಂದಿದ್ದಾರೆ ಅಂತೀರಿ? ಇಲ್ಲ ಸರ್, ಬೆಂಕಿ ಬಿದ್ದಿದೆ ಎಂದು ಸ್ವಾಮಿ ಪ್ಯಾರಾ 8, ಬೆಂಕಿ ಬಿದ್ದಿದೆ ಎಂದು 1000 ಜನ ಸೇರಿದ್ದರು, ದಾರಿಯಲ್ಲಿ ಓಡುವವರು ಸಹ ಬಂದು ನೋಡಿದರು. This is what she speaks.
Yes.
About the time when the incident took place. It was to the gaze of thousands of persons. Thousands of persons witnessed it. When thousands of persons were witnessed, before they all dispersed from the place, nobody said A1 having been responsible for the incident. Nobody said. If his name had emerged as the one setting fire, my lord, all of it should have been all pervading. That name should have been all pervading. Everyone assembling there, thousands of persons also should have equally come to know of his name as having been responsible. Then, Swami, para 9. ನನಗೆ ನೀಡಿದ ಹಕ್ಕುಪತ್ರದಲ್ಲಿನ ಜಾಗವು ಬನ್ನಿ ಮರದ ಕಟ್ಟೆ ಸರ್ವೆ ನಂಬರ್ 26 ರಲ್ಲಿ ಗೋಮಾಳದ ಮೀನು ಎಂದರೆ ನನಗೆ ಗೊತ್ತಿಲ್ಲ. It was a site in this survey number had been allotted to her husband, not the one where they were staying. ನನ್ನ ಮಗನಿಗೆ ಗೊತ್ತು ಎನ್ನುತ್ತಾರೆ, ಆದರೆ ಹಕ್ಕುಪತ್ರ ಇದೆ ಎನ್ನುತ್ತಾರೆ. When the question was on the same score put to PW to her son, he also came out with the same answer. ನೀವು ಹಾಜರುಪಡಿಸಿರುವ ಹಕ್ಕುಪತ್ರದಲ್ಲಿನ 13ನೇ ನಂಬರಿನ ನಿವೇಶನ ಸೇರಿದ್ದು ಆಗಿರುವುದಿಲ್ಲ, ಬದಲಿಗೆ ಕಾಳಯ್ಯ ಬಿನ್ ದೊಡ್ಡ ನಾಣಯ್ಯ ಅವರಿಗೆ ಸೇರಿದ್ದಾಗಿರುತ್ತದೆ ಎನ್ನುತ್ತೇನೆ, ಏನನ್ನುತ್ತೀರಿ? ಹಕ್ಕುಪತ್ರ ನಮಗೆ ಕೊಟ್ಟಿದ್ದಾರೆ. ದಟ್ ಇಸ್ ಅವರ್ ಆನ್ಸರ್. ಶಿ ವುಡ್ ನಾಟ್ ಡಿನೈ. ಎಕ್ಸಿಬಿಟ್ P2 ಹಕ್ಕುಪತ್ರ ಸುಳ್ಳು ದಾಖಲೆ ಎನ್ನುವುದು ಸರಿಯಲ್ಲ. ದೆನ್ ಪ್ಯಾರಾ 13 ಲೈನ್ ನಂಬರ್ 3, ಘಟನೆಯ ನಂತರ ಶಿವರಾಮಯ್ಯ ಅವರು ಊರಿನಲ್ಲಿ ಇದ್ದರು ಎನ್ನುವುದು ನಿಜ. ಘಟನೆಯ ನಂತರ ಇನ್ಸ್ಪೆಕ್ಟರ್ ಶೇಖರ್ ಅವರು ನಮ್ಮ ಊರಿಗೆ ಬಂದು ಹೋಗುತ್ತಿದ್ದರು ಎನ್ನುವುದು ನಿಜ. 4-5 ಬಾರಿ ಒಂದು ಹೋಗಿದ್ದಾರೆ. ಬಟ್ he never recorded their statement. It was recorded after 40 days. Then ಫಿರ್ಯಾದನ್ನು ಕೊಟ್ಟ ನಂತರ ಪೊಲೀಸರ ಮುಂದೆ ನಾನು ಹೇಳಿಕೆ ನೀಡಲಿಲ್ಲ ಎನ್ನುವುದು ಸರಿ.
1 minute, I will hear the, yes, what is it regarding improvement? Presence, right. She says they were holding her. They were accused number 1 to 6 were holding her, and some other person has set fire. Procedural ಹೇಳ್ತಾರೆ, it was accused number 1 alone who was set fire. And charge is all accused number 1 to 6 with common object came and all of them have set fire. Inconsistency. And most importantly, PW1 who is the informant states in the written information, accused number 1 to 6 were holding me while the others have set fire. Who is that other person? Only overtake that was alleged against accused numbers 1 to 6 is holding CW1, PW1. Yes. Correct. And PWs 1 to 3 are the family members. Except that there are no other evidence. PW5 I think. PW4 partially hostile. Yes. And PW5 came to this picture, fire extinguisher. Avrenu helalla.
ಇಲ್ಲ ಇಲ್ಲ.
Then so the only interested version of PW is 1 to 3. And admittedly there was rivalry between the two. So how can it be believed to convict the accused? And to 25 other persons. But she left everybody else and stated it was accused number 1 who set fire. Cannot be believed. Third. Accused number 1 to 6. In the SC 147 of 2011 on the file of the Learned Principal Sessions Judge Tumkur are impugning the judgment of conviction and order of sentence dated 2nd March 2012, convicting the for the offense purpose so and so and so. The facts of the case made out by the prosecution is that there was a galata between PW1 and accused number 1 and others since long. Accused number 1 was the former member of Jilla Panchayat, and he was claiming the right over the site over which PW1 had constructed a hut. It is the further contention of the prosecution that on 14/12/2009 at 12:30 p.m. accused number 1 to 6 forming unlawful assembly with the common object of setting fire to the dwelling hut belonging to PW1 came to the spot, set fire, as a result of which the hut as well as the food grains and other household articles were burnt, causing damage to the tune of ₹12,000. And thereby they have committed the offense. The accused have appeared with the magistrate took cognizance of offense for the aforesaid offense. The accused have appeared before the court and pleaded not guilty. They claim to be tried. The prosecution examined the exhibit P1, got marked exhibit P1 to 5, identified MO 1 and 2 in support of its contention. Accused have denied all the incriminating materials available on record, but have not laid any evidence in support of their defense. However, exhibit D1 and 2 were marked during cross-examination of the prosecution witnesses. The trial court, after taking into consideration all these materials on record, came to the conclusion that the prosecution is trial court has came to the came to the conclusion that the prosecution has failed to prove the guilt of accused number 2 beyond reasonable doubt and acquitted him. However, it is held that the prosecution is successful in proving the guilt of accused number 1, 3 to 6 for the aforesaid offences and sentence them accordingly. Being aggrieved by the same, the accused are before this court. Third, so superiority, my answer to above point in the affirmative for the following reasons. It is the specific contention of the prosecution that accused number 1 to 6 have formed unlawful assembly with the common object of setting fire to the dwelling hut belonging to PW1, and on the date of incident, they came to the spot and set fire to the hut, as a result of which the hut, food grains, and other household articles were burnt, causing loss of about 12,000 to PW1. My attention was drawn by the learned counsel for the appellant to the first information exhibit P1, which was filed by her at the first instance. According to exhibit P1, the same was filed by PW1 on 14/12/2009, that is on the date of incident at 7 p.m. 7 p.m. As per this exhibit P1, accused number 1 to 6 along with others came near the house of PW1 and they have caught hold of PW1 while the others have set fire. Exhibit P1 categorically refers that the persons who are belonging to accused number 1, who are related to accused number 1, have set fire on her shed. If at all, but when the informant was examined as PW1 before the trial court, she has given a go-by to her earliest version and stated that it was accused number 1 who set fire to the hut and caused losses. Next, the materials on record discloses that there was long-standing ill will between PW1 and her family members as against accused number 1. It is stated that accused number 1 was claiming the site on which PW1 had constructed a hut and was staying there. It is also the case of the prosecution that PW4 had came to the spot on the date of incident for the purpose of measuring the property and to report it to the Jilla Panchayat. His presence is not disputed, but even though he is examined before the trial court, he never states about commission of the offence by the accused. He was treated partially hostile and he was cross-examined by the learned prosecutor, but nothing has been elicited from him to disbelieve his version. Therefore, only the version of PW 1 to 3 is available to speak about commission of the offence by the accused. PW 2 is the son and PW 3 is the brother of PW 1. They are all family members. As I have already stated, there is a fatal improvement made in the case of the prosecution, which is not explained. It is also pertinent to note that the FIR was going to be filed against accused numbers 1 to 6 and 25 other persons. Even while filing the charge sheet, the investigating officer has not found out as to who are these other persons who accompanied accused number 1 to 6. When a serious doubt arises regarding the overt act committed by accused number 1 to 6 in setting fire to the house of PW1, the benefit of doubt is to be extended to the accused and they are to be acquitted. Okay. Next, I have gone through the interim judgment of conviction and order of sentence passed by the trial court. The trial court has proceeded to accept the interested and improved version of PW1 to convict accused number 1326. 1326. There is absolutely no explanation as to why there was such a drastic improvement in the version of PW1 when she filed the first information and when she deposed before the court. Under such circumstances, I am of opinion that the improved judgment of conviction and order of sentence is liable to be set aside accordingly. Except the point in the affirmative and proceed to first according appeal is allowed. Improved judgment of conviction and order of sentence set aside as a result. The appellants are acquitted at two number 1, 3 to 6 are acquitted for the offence punishable on section so and so their bail bond and that of their surety and cancelled permanent if any deposited if any shall be returned. Appeal is allowed. Yeah. ಈಗ ಆಗಿದ್ಯಾ 16 14 ಆಯ್ತು.
Serial number 13, K. Chandrasekhar, connected matter Dinesh Rao, P. N. Negde, P. Prasanna Kumar.
The morning session asked me, what about the accused number 4 is concerned? Accused number 4 had filed appeal in 811 of 2011. Since he's passed away during the appeal, this court has ordered abating of the appeal against the person on 5/6/25. 5/6/25. Now only A1, A2 and A5.
3 and 4 are already abated.
Yes.
Yes. Kudi.
So I appear in criminal appeal number 790 of 2011.
Yes, what are the offence alleged?
The offence alleged against all the accused persons are 120B, read with 409, 420, 467, 468, 471, 477A of IPC. Then the provisions under the PC Act 13(1)D of Prevention of Corruption Act, that is in reference to accused number 1, public servant. Well, so far as the charge is concerned, well, the charges are framed for 120B, 420.
No, they were not convicted for 467.
467.
They were not convicted for 467.
No, my lords, the conviction is only for, my lords, 120B, 420, 468, 471 and 477A.
And 409.
Yes, 409.
Ah.
409, I think, is against the government.
Accused number 1 under 13(1)(d).
Yes.
Yes. Explain brief facts of the case, how the incident had occurred. What is the condition?
The brief facts of the case is, my lords,
accused number 1 is?
Accused number 1 was the manager.
Manager of?
The manager of Corporation Bank, SR Road branch, that is Sayaji Road branch at Mysore. Between, my lords, 1998 to 2000.
Yes.
My lords, the allegation is, my lords, during his period, my lords, A2 and A5 have mobilized a foreign currency residence deposits, FCNR. They mobilized the amount from for the NRIs to be deposited under the FCNR account.
They deposited?
Yes.
Accused number 2 and 5.
2 and 5 have mobilized. They have not deposited.
They mobilized the
They
foreign
mobilized, so NRIs have deposited.
Accused number 2 and 5, what they were doing?
They are private parties.
Accused number 5, chartered accountant.
Private parties. They mobilized, so they ensured that the certain non-resident Indians makes the deposits. Well, also having the accused number 1, having taken the deposits, conspired with the other accused persons and granted a loan to accused number 2, 3 and 4. Granted a loan to 2, 3 and 4 by creating a lien on the foreign currency non-residence deposits.
Granted loan to accused number 2, 3.
2, 3 and 4 by creating the charge on the deposits made by the NRIs.
Yes.
Because the allegation is during the course of the entire transaction, the accused number 1 alleged to have forged the signature of the depositors, manipulated the bank documents,
Yes.
Mallards, if I go by each one, Mallards, the persons who have deposited, because so far as accused number 2 is concerned, Mallards, the deposit made by.
See, the major allegation is creating charge over the deposit made by NR.
Yes.
Granting loan to accused number 2, 3, 4.
It is effectively 2, 3 and 4 are the beneficiaries.
Yes.
The beneficiaries of the.
How many witnesses are examined?
Mallards, in all, Mallards, 35 witnesses are examined.
Exhibits P1 to?
Mallards, the total, the exhibits. Mallards, the total exhibits marked is 386.
Any MOs?
38, no MOs.
Defensive?
Now, so far as the defense is concerned, Mallards, the 5th accused, the accused number 5 has examined for the, in all, the 4 witnesses. 4 witnesses, no documents are marked.
How much time you may require?
Let's may take about 45 minutes.
One minute. There ಏನಿದೆ? I'll just adjourn other matters and take up.
Please.
Serial number 17, check sir. 17.
17 ಇಲ್ಲ. ಅದು ರಿಪೀಟ್ ಮಾಡಿ ನಾಳೆ. Then
Serial number 20, MS Venkateshaya, connected matters.
17 ನಲ್ಲಿ counsel for the appellant is absent. To afford one more opportunity tomorrow. Next.
Serial number 20, MS Venkateshaya.
Counsel for the appellant is absent on representation list of the 4 months. 4 weeks. ಅಷ್ಟೇನಾ? ಏನು ಬೇಲ್ ಆರ್ಡರ್? ಅದಾಗುತ್ತೆ. ಇನ್ ರೆಗ್ಯುಲರ್ ಕೋರ್ಸ್ ಇಮಿಡಿಯೇಟ್ಲಿ ಇಟ್ ವಿಲ್ ಬಿ ರಿಲೀಸ್ಡ್. ಅರ್ಜೆನ್ಸಿ ಏನು? ಅದು ಯಾವುದು ಇಂಟ್ರಿಯಂ ಬೇಲ್ ಇದ್ದಿದ್ದು ತಾನೆ? ರೆಗ್ಯುಲರ್ ಆಯ್ತು ತಗೊಳ್ಳಿ. ಒಂದು ಕಡೆ ಟಾಪಿಕ್ ಹಾಕಿ ಒಂದೊಂದು. Yes. You need not have to go elaborately.
Yes, ma'am.
Nutshell ನಲ್ಲಿ ಏನು ಅಂತ ಹೇಳಿ.
Nutshell, my lords, if I could able to bring it to the notice of the court, my lords.
What are the grounds? Tell me.
Now, the grounds is in way IO has not stepped into the witness box. IO has not stepped into the witness box.
Yes, then.
My lords, so subordinate of the IO comes and says, I am conversant with the signature of the invitation.
I was not examined.
My lords, I don't know the prosecution, why the prosecution has, because I'm informed that he was secured before the court and he said he has already taken a sannyasa in the life. So that's why he don't want to lie before the court.
Okay. First tell me the bullet points. What are the grounds? Then you can elaborate.
Yes, my lords. My lords,
His IO is not examined.
IO has not been examined.
Second one.
My lords, the second one is, my lords, no evidence to show that there is a meeting of mind between the accused number 225 at one end and the accused number 1. No meeting of mind. There is no documents at all.
Document ಏನಿರುತ್ತೆ sir?
Document ಇಲ್ಲ, evidence ಇಲ್ಲ. My lords, even there is no evidence at all.
Next.
Evidence also. There is no evidence. No meeting of mind. My lords, the judgment of the trial court is essentially based on the observation made by the IO in the final report, not based on the evidence of the prosecution.
Yes.
My lords, it is not the case of the prosecution. In the, my lords, divorce of 120B, 120B, there is no material to show that either the accused number 225 are indulged in fabricating a document or forging the signatures.
Who forged the document?
This is according to the witness, it is A1.
A1.
A1 ಮಾಡಿದ್ದಾರೆ ಅದನ್ನ.
ಅದಕ್ಕೆ documents ಏನಿದೆ?
But the documents were produced and it was the report was obtained from the Central Forensic Science Laboratory. And the certain officers of the bank also identifies his signature as well as his handwriting. But there is absolutely, my lords, not even a piece of papers which shows or evidence which shows that the accused number 225 are in any point of time conspired with A1, except in the saying that they know each other, that's why they have conspired. There is absolutely no other materials.
So according to you, there is absolutely no material against accused number 225?
Yes.
For having committed any offense?
Yes. They are only the, as per the records, plus the fact and certain admitted facts are there. Admitted that the loan has been sanctioned.
They only borrowed the loan.
Yes, 2 to 4 has borrowed the loan. 5 was the facilitator. According to them, he was a facilitator.
Yes. Then
Because apart from that, my lords, this is actually, my lords, if I could able to draw the attention of this honorable court, the role played by each of the witnesses. Either the witnesses who states that accused number 1 had come to their hotel and stayed, the hotel nearby the bank.
here out of 35, who are the material witnesses?
Except the officer who has conducted the internal inquiry, that is PW13. PW13 is the officer who has conducted the internal inquiry in the bank.
What is his designation?
He was the deputy manager of vigilance cell of the corporation bank.
He supported.
He has said, I conducted the internal inquiry. I found the irregularities. Hence, I instructed the concerned to lodge a complaint. He has supported.
Whether he has submitted a report?
Yes, my lord. He has submitted a report to that effect.
Exhibit.
Yeah. Now, except this witness, there is no other witness at all. My lords, in fact, even the 2 investors were examined before the trial court. They do not say that any of this accused number 2 to 5 are indulged in mobilizing the money. They have invested the money through their tax consultants, financial consultants.
They may not be knowing. They
And
may not be knowing.
even financial consultants were examined. They said, we have mobilized the money. No one has speak about accused number 2 to 5.
Mobilizing the money may not be an offense.
Plus the very basis for the case of the CBI is, we have induced, or rather, we are the instrumental in getting the money from the foreign non-resident Indians and getting it deposited in the bank. They want to ensure that we have started, our intention was there right from the beginning. But tax consultants and the investors, neither of them speak about the involvement of the accused number 2 to 5.
Your internal inquiry report ಯಾವುದು?
Internal inquiry report ಯಾವುದು? My lords, I just borrow one. 13. Internal inquiry report, PW 13.
There is no.
Whose signatures were forged?
My lords, the depositors.
Whether they are examined?
My lords, the depositors, 2 depositors were examined.
PWs?
My lords, the depositors are, my lords, PW 27,
Hmm.
PW 27 and PW 33, 27 and 33. Out of 5 depositors, 2 depositors were examined.
They have supported.
My lords,
They have supported.
my lords, they have spoken before the court that they have not given a standing instruction to the manager to create a charge on their deposits.
When PW 27 and 33 specifically state that they have not instructed A1
Yes,
to create a charge,
please.
where accused number 1 stands?
My lords, I'm afraid to say that A1 has a big obstacle to cross. My lords, A1 has a big obstacle to cross. So far,
Prima facie, I am seeing that.
he has a big obstacle to cross.
Other accused, of course,
2 to 5, my lords, if we could able to come across 120B, my lords, we can definitely persuade this on.
it is very difficult to prove 120B, of course. But A1 prima facie,
A1, it's very difficult.
and FSL report,
My lords, FSL report is that the FSL officers are examined as PW 26 and
report,
my lords, his report is marked as, my lords, 386. PW 26, his report is 386.
$386.
Yes.
What is the finding, final opinion?
My lords, final opinion, my lords, a disputed handwriting and admitted handwritings matches, tallies.
The person who has done the sample handwriting
And
is the author of the disputed handwriting.
Yes.
That is disputed handwriting, admitted handwriting is that of accused number 1.
Accused number 1. My lords, even the other accused signatures were also taken. My lords, the account opening form. Because, my lords, when I take a loan from the bank, I need to have an account in the bank. My lords, in the account opening form, to ensure that it belongs to a particular person, my handwriting and my signatures on the relevant papers were also sent for the examination.
No, as per FSL report,
Yes.
whose signature tallied with the disputed?
So we may have to fall back on the documents as such, because the ಇವ್ರು ಏನ್ ಹೇಳಿದ್ದಾರೆ ಅಂತಂದ್ರೆ ಇವರು ಎವಿಡೆನ್ಸ್ ಒಳಗಡೆ ಡು ನಾಟ್ ಸೇ ಯಾರ್ದು ಡಿಸ್ಪ್ಯೂಟೆಡ್ ಕ್ವಶನ್
ರಿಪೋರ್ಟ್ ನಲ್ಲಿ ಹೇಳ್ಬೇಕಲ್ಲ ಅವರು ಏನು ಒಪಿನಿಯನ್ ಏನಿದೆ ಫೈನಲ್ ಒಪಿನಿಯನ್.
ಫೈನಲ್ ಒಪಿನಿಯನ್ ನಲ್ಲಿ ಅವರು
ಒಪಿನಿಯನ್
my lords, this is what the my lords, in page number 345 of the paper book ಅಲ್ಲಿ
ಪೇಪರ್ ಬುಕ್ ಇಲ್ಲ, ನಾನು ಒರಿಜಿನಲ್ ನೋಡ್ತಾ ಇದ್ದೀನಿ.
ಇದರಲ್ಲಿ ಅವ್ರು ಏನ್ ಹೇಳ್ತಾರೆ, on perusing question document 229 found alterations in the first 2 figures which were disappeared and read as 25. On perusing question 220, question 228, I found obliteration which were disappeared and read as 5 followed by 50. Because there's a lot of alterations were taken place in the document, in the bank document. So
Yeah,
those
very
documents
strange.
were also sent to the FSL, and the FSL has given a report that there is a marked alterations in the each of the document.
No. Whether he has stated the specimen signature, the standard signature tallies with the disputed one. Writings are signatures.
Yes.
ಅದು ಎಲ್ಲಿದೆ?
Man.
See, in page number 18, the authorship of the questioned signatures marked as Q390 to Q394 could not be connected with the writer of the standard signature marked as S270. ಅವೆಲ್ಲ ನೀವು ನೋಡಿ ಹೇಳ್ಬೇಕಪ್ಪ. Do not tally ಅಂತಂದಿದ್ದಾರೆ. ಅದು ಯಾರಿಗೆ ಯಾರಿಗೆ ಸಂಬಂಧಪಟ್ಟಿದೆ?
My lords, in fact, the ಇವ್ರದ್ದು ನಮ್ಮ ಎಕ್ಸ್ಪರ್ಟ್ ರಿಪೋರ್ಟ್ ಅನ್ನೇ ಇದ್ರೊಳಗಡೆ ಪೇಪರ್ ಬುಕ್ ಅಲ್ಲಿ ಹಾಕಿಲ್ಲ ನಾನು.
Sir, I think you need not have to address elaborate arguments.
Yes.
If it is sufficient, the internal inquiry report, what does it say? FSL report, what does it say? If it is matches, it matches with the signature or handwriting of whom, which accused?
Well, there are many writings were sent and signatures. Well, there are two set of documents. One is altered and manipulated documents. That is FCNRs. In connection with certain papers were manipulated, allegedly manipulated. But those papers were also sent. The another set of papers and signature is mine. For example, when I opened the account for seeking the loan, I make an application and I give a letter, all those things. Well, those handwriting and signatures were also sent along with my admitted, only to find out whether I should not tomorrow deny that I have not taken the loan. Well, we are categorically admitting that there is a loan has been sanctioned to us. That is not a disputed aspect at all.
No, but NRIs PW 27 and 33, they do not say that they have requested accused number 1 to create
Yes.
a charge.
Yes.
Dispersing of the loan may not be a problem.
Yes.
Who authorized you to create lien or charge?
A1 has absolutely no
Defense.
Well, that's why I made a submission. Well, the A1 has got a big, very serious.
That is what I could gather from your
Yes.
arguments.
He has a very serious
Others
substitute.
may escape, but
Yes.
not accused number 1. Because there must be authority given by the depositor to create lien. You may disperse the loan.
Yes.
Nobody can question. But who authorized you to create charge?
Create a charge.
There must be something.
Yes.
When internal inquiry committee has given a report, definitely it will go against accused number 1.
Accused.
Not against others.
Yes. And in fact, we have not even, except 1 or 2 witnesses, we have not even cross-examined any of the prosecution witnesses.
I think PW 13, 26. Then who else? Complainant, who is complainant?
Well, the complainant is PW 20. 23. PW 23.
What is his designation?
Well, he is a DGM zonal head of the corporation bank. DGM. Zonal head. Well, all that he says is, well, based on the inquiry report, the letter at exhibit 173.
173 now.
Inquiry report 173.
Yes. So he speaks only about the inquiry report. Based on that, I have filed the complaint.
That's all.
So PW 13 is the material witness.
Material witness.
Coupled with PW 26 FSL expert.
FSL expert.
ಅಷ್ಟೇ.
ಇದು ಎರಡು ಬಿಟ್ಟರೆ ಮತ್ತೆ ಏನು ಇಲ್ಲ. ಅಬ್ಸಲ್ಯೂಟ್ಲಿ ಏನಿಲ್ಲ. ಎಲ್ಲರೂ ನಾವು ಸಿಗ್ನೇಚರ್ ನೋಡಿದೀವಿ, ಇದು ಮಾಡಿದೀವಿ.
ಅದೆಲ್ಲ ಬೇಕಾಗೇ ಇಲ್ಲ.
That's all. Except these two, there is no other material witnesses. Of course, against the A1, these investors, they say, 2 investors, they say we have not mandated him to create the charge. create the charge. There are other two
And
witnesses.
whether accused number 1 has taken any defense that I was authorized on the, ಯಾರು ನೀವೇ ತಾನೆ?
ಇಲ್ಲ, ನಾನು A2 ಗೆ
A1 ಗೆ
A1 ಗೆ
yes, whether you have taken any defense.
I will have to go. Yes, my lords, I have taken several contentions.
Several contentions. What is your specific defense? One ಹೇಳಿ first.
No financial gain. And the IO has not been examined.
Who authorized to create lien or charge over the deposit?
That is the mystery, my lords.
Huh?
That has been a mystery, my lords.
Everything is mystery as far as accused number 1 is concerned. You are the person who has to explain. You accepted the deposit, you sanctioned the loan, you disbursed the amount, you created the charge, and you are answerable. None else. Others can easily escape. Because they are not authorized to do any of these jobs. They are outsiders. It is only accused number 1 who is responsible. ಏನು 313 statement ಅಲ್ಲಿ ಏನಾರು ಹೇಳಿದ್ದೀರಾ? You have not stepped into the witness box to explain. ಏನು PW 13 what is your cross examination? 13 and 26.
Page number cross examination.
Cross by accused number 1. ಏನು only suggestion no denial ಏನು ಏನಾರು positive ಏನಾದ್ರು
He
ಇದೆಯಾ?
says there has been an audit, my lords, monthly audit, annual audit, and external audit. He says and he admits that there were no irregularities in the audit. Point number 66 minutes. Point number 66.
PW ಕೊಡಿ, PW 13 ಎಲ್ಲಿದೆ? ಇದೆ ಎಲ್ಲ ಎಕ್ಸಿಬಿಟ್ಸ್ ಅಲ್ವಾ? 13 PW 13 ಇದರಲ್ಲಿ ಇದೆಯಾ? ಎಲ್ಲಿದೆ? PW 13. Read the cross examination.
I do not know whether there is 10 months delay in filing the complaint. Therefore, I cannot say the reason for the delay in filing the complaint.
Yes.
If it is put to me that whether the bank manager was having the power to grant the loan on FCNR receipt, I would like to say that he was having such power. It is mandatory on the part of the manager to verify the signatures on loan account opening form and signatures on the passport. I was not met the FCNR depositor and was not conduct the inquiry regarding their according or non-according their consent for availing the loan on the FCNR receipts. I have not verified the postal address of one Gulab Kanyalal Paryani. It is true to say that there was a practice in the bank to keep amount towards FCNR receipts and suspend account.
Immaterial level. That will not help you anywhere.
Next paragraph. It is true to say that whether the loan was repaid, the lien on the FCNR receipts were cancelled. I do not know whether A1 has rendered his blameless service of 25 years. I do not know whether appreciation letter was issued to A1 regarding his satisfactory service. It is true to say that in the said branch was yearly concurrent audit. It is true to say that there was no report regarding any irregularities noticed during such audit. I do not know whether FCNR deposits were using to be received from the persons who were not having the license. I do not know if the said deposit or through the persons who are not having the license is against guidelines of FERA and FEMA guidelines. Next, I do not know whether the FCNR depositors were paid the amount of their deposit by the bank. I do not know whether there was any demand by the depositors for the payment of the deposit amount. Without going through the letter, I cannot say that.
That's all.
That's all.
Nothing regarding creating charge.
But he says that there were, according to the audits, there were no irregularities found during the relevant period.
Sir, that is the fraud. The word itself suggests there will be concealment, secretly executed. Even the auditor cannot find out. Then what is the cross-examination to this PW 27 and 33?
He says that he doesn't know A1.
No, regarding authorizing accused number 1 to create charge, whether there is any cross-examination.
My lords, he says,
Hmm?
he says that nobody has told myself that I was to invest FCNR deposit at the corporation bank. Besides, you wrote, the manager corporation bank Mysore was not sent any letter to myself requesting for the FCNR deposits. No incentives apart from the interest on FCNR deposit was paid to myself
We are
by the
not
bank.
concerned about the deposits. Now we are concerned on the basis of the deposit. Loan was sanctioned to so and so. Even that cannot create any problem for the accused. Creating charge on the FD. Who authorized you? I think you cannot wriggle out of the situation. Who authorized you to create charge? Where is the authority? Yes, what is the material?
Your Lordship,
Anybody?
Your Lordship, the entire case is that certain persons are
I
purport.
thought that he has
No,
already
what I am
explained.
trying to put across is those persons whose FDs are purported to have been made have never been examined.
Who are they?
They are the persons named in the charge, not examined. Not so, the Lordship may see the charge, which will be at page 253. Agreement with them treated the account holders, namely Gulab Kanailal Paryanani.
Two of them are examined. Two of them are examined.
The Surendra Pal Sahani, only one. If your Lordship sees the judgment, the end of the list, at page number 161, Vinod Kanayalal has been examined.
Yes.
as PW 33.
And 27.
Nagdev Ramesh. But these persons have not been done. There are number of fixed deposits.
See, at least 2 of them are examined.
Yes, clear.
Why
Question
their evidence
is
should not
secondary.
be?
Secondly, signatures have not been charged.
Whom you are representing?
I am appearing for accused number 5, the chartered accountant.
Somewhere. Accused number 1 to kelta ideni. He is the person.
It boils down to accused number 1.
It is very difficult to him for him to wriggle out of the situation. That is what I am saying. Others may easily escape. But he is admittedly the manager.
Please.
Who sanctioned loan, who created charge.
It is within his jurisdiction.
Yes. He should say who gave him the authority. Unilaterally, he cannot create charge. The depositor must give authority. Where is the authority? At least 2 depositors, PW 27 and 33, they say we never gave any authority. Then where do this accused number 1 stand? In cross-examination, nothing.
Nothing. There is no cross-examination. I am a very poor cross-examiner.
Yes.
Rather, I must concede to the fact.
That is why I asked him to read the cross-examination. Even if the entire cross-examination is read, there is nothing.
Nothing.
Then
I have to fall back on the failure of the prosecution to prove its case. That's all.
So I asked Mr. Hegde, don't waste the time by referring so many documents and evidence. Only internal inquiry committee,
report,
inquiry officer, his report, FSL report, FSL evidence, and PWs 27 and 33. That's all. Even though the trial court records are in several volumes.
They are not required. I mean, only the relevant things have been.
Yes.
And then secondary evidence has been led, Your Lordship. My humble submission is those documents should be excluded from consideration.
What you are doing before the trial court?
Of course, no objections have been raised.
Yes.
Let me be fair to the court.
Then,
but the fact is, it couldn't have been done.
When no objection was raised, even the Xerox copies are permitted.
And IO has not been examined. I mean, these are the.
Even if IO is not examined.
Enough material is there would be one of the stands.
Against accused number 1, there are enough material.
Enough material.
And IO cannot explain anything. He can say only on the basis of the materials on record. He cannot have any
linking of the material would be his jurisdiction.
That's all. In other criminal cases, maybe IO may be material witness. He has not collected documents, produced it, filed the charge sheet. That's all. Yes. This is the problem we are having. And I have to invest another 2 hours for this on another day. Where is Mr. Prasanna Kumar? Ask him to come. Please ask him to come. Yes, anything?
My senior is on his legs.
Ask him to come if you want. Otherwise, I'll proceed. Please ask him to come. Call him. What is the role attributed to other accused? Accused number 2 and 5. What is the role? What is the role?
The allegation being made against accused number 5 is he is the person who forged it.
No, accused number 2 and 5, they conspired with accused number 1.
2 to 4 are the borrowers.
Committing the offense.
120B.
2 and 5 mobilize the
amount.
1. Number 2, they have conspired with the.
Correct.
But end of the day, operational, as your lordship put it across, acting thereupon and creating of the loans and etc.
Mobilizing funds may not be an offense.
Please.
Right? They will mobilize the fund. We cannot find fault with them. Even if that is to be accepted, conspiracy, positively we cannot lead any evidence.
It has to be inferred.
It is to be inferred. But accused number 1, there is a positive evidence. ಅಷ್ಟೇ ಅಲ್ವಾ ಇದರಲ್ಲಿ ಇರೋದು?
That's all. That's all. At least 2, 3 and 4 are the beneficiaries. 5
nothing.
Not even the recipient of the.
In fact, he suffered also. His practicing certificate was cancelled and from the chartered accountants, and he is suffering. From a chartered accountant, he has been relegated to a for the income tax practice.
Even if it is to be accepted that accused number 1 granted loan to accused number 2, 3, 4, granting loan, availing loan is not an offense.
But based on what documents? Then it will boil down to that. Based on what documents?
Forged document.
Is forgery proved would be the question.
But accused number 2, 3, 4 can stay away. But accused number 1 should have been stepped into the witness box to explain. If in fact he had not committed any offense, it was his duty to explain under what circumstances that has happened.
All casual like cross examination.
ಅದೇ ಕ್ರಾಸ್ ನಲ್ಲಿ ಏನಿಲ್ಲ, absolutely nothing.
All the appeals that your lordship is going to see in the next few days, he'll have the suffer the same. ಅಷ್ಟೇ.
What I have observed, the CBI, they will come and they will examine all the witnesses. They will say, I have seen this document, I have seen this document. And linkage of the document and the ultimate opinion of the IO has not been reduced into evidence. Now the courts are falling back upon the observation made by the IO under 173. Let's see, the apex court in the Kaptan Singh's case, the apex court has taken a view that the report of the opinion of the IO under 173 is only for the purpose of taking the cognizance.
Yes.
The rest of the things, it has to be brought out in the evidence, in the witness box. That is not being done in any.
And your lordship would also notice that persons unconcerned are examined. Technically, it would be hearsay evidence.
That is why I was wondering why the several hundreds of witnesses are examined.
All hearsay evidence, your lordship. If you apply that Gogoi's judgment of the Honorable Supreme Court, all of this evidence will have to be rejected.
35 witnesses are examined.
Much work. Carrying coal to Newcastle. Nothing. Flogging a dead horse.
According to me, only these 4. There may be another 1 or 2 witnesses.
In fact, your lordship, I must be fair to say to this court, with my experience in the trial court in CBI matters, unlike other courts where prosecutors are there, they give up witnesses. Here, the prosecutors are frightened to even give up witnesses.
Sir, but at least the court must ask why you are examining these witnesses.
CBI matter.
That is done. It is very difficult.
130, 140 witnesses, your lordship.
For what purpose?
For the same issue, 5 people, 6 people will be talking. And all of them on hearsay basis.
And it is nothing but burden on the court.
Please.
Though the prosecution is not taking steps, we are giving, as a defense counsel, we are giving 294 applications. We give the applications, we admit these documents.
Yes.
So in connection with that witness, passive witnesses, they can be.
In some of the trial courts, they hold this pre-trial conference with the prosecutor, with the advocate for the accused. We hold that inquiry. Initially, the advocates were not ready to participate, but later they understand the importance. Only the material witnesses will be examined. And beforehand, you will be knowing why that witness will be examined, what he is going to speak. And court will also be knowing what the witness is going to say and why he is
And
to
the
be examined.
relevancy thereof.
Yes. And it will be very easy to form an opinion.
Please.
Otherwise, we do not know where we are heading, what the witnesses are saying, why we are recording the
In
evidence.
fact, in the CBI court in Delhi, the judges do that. They read the statement themselves and then say, forget it, this is not required. And they pass an order to the people.
I was not in CBI court, but in any other sessions court, I used to ask, what the witness say? Why you are examining them? And used to ask the counsel for the accused also, do you dispute that document? If not, mark it. That would save the time of the court in recording evidence, hearing argument, judgment, everything. So what? Judgment. PW 13, 20, 13, 26, 27, 33. ಮೂರಕ್ಕೆ paragraph D. 13, 26, 27, 33. Then exhibit P 173, 386. Appellant in criminal offense 724, 2011 being case number 1. Appellant in criminal offense 790 of 2011 being case number 2. Appellant in criminal offense number 741 of 2011 being case number 5. For impugning the judgment of conviction in the order of sentence lodged in special CC number 54 of 04 on the file of so-and-so, convicting them for punishable under section so-and-so, so-and-so, so-and-so. Today, judgment of conviction and order of sentence dated 4th July 2011. The case of the prosecution made out to the trial court is that accused number 1 being the manager of Corporation Bank SR Road branch. Please be seated. Corporation Bank SR branch road, Mysore, was a public servant at Mysore during 1998-2000. Was a public servant, and he conspired with accused number 2 to 5, and they have fraudulently created charge, forging the documents and making use of those documents as genuine, falsifying the account referred to in the charge. It is stated that the accused number 1 in collusion in furtherance of their common object, accused number 1 in furtherance of his common object, criminally conspired with accused number 2 to 5, forged the form opening FCNR account number 4 of 1999 by forging the signatures of the depositors, forged the parallel deposit receipt and the ledger folio, and managed to delete the condition found on the receipt, deposit receipt bearing number 125014 and 125015 by removing the condition not to create any lien and cheated the bank by by granting the loan to accused number 2, 3 and 4. Accused number 2, accused number 2, loan of rupees 52 lakhs. Accused number 3, loan of rupees 45 lakh. 4, loan of rupees 30 lakhs. On security of the FCNR number 4 bar 99, 20 bar 99, 15 bar 2000 and 16 bar 2000.
I may take permission.
Yes, yes, yes. And thus accused number 1 fraudulently allowed accused number 2 to 5 to avail the financial accommodation of rupees 175.74 lakhs and the accused have misappropriated the same. They have committed criminal breach of trust. Accused number 1 being the public servant caused pecuniary accused number 1 being the public servant was a party to the criminal conspiracy with accused number 2 to 5 by corrupt and illegal means obtained pecuniary advantage of rupees 5,60,600, committed misconduct. And thereby committed the offence punishable under section so and so. The investigating officer, after investigation, filed the final report against accused numbers 1 to 5 for the aforesaid offence. When the magistrate took cognizance of offence, the accused have appeared before the trial court and pleaded not guilty. They claim to be tried. Prosecution examined the PWs 1 to 35. Got marked exhibit P1 to 386. The accused have denied all the incriminating materials available on record in their statement under 313 CRPC. Accused number 5 got examined DWs 1 to 4 in support of his defense. The trial court, after taking into consideration all these materials on record, came to the conclusion that the prosecution is successful in proving the guilt of accused number 1 to 5 for the offence punishable under section 120B, read with 420, 468, 471, 477A, 409 of IPC. And accused number 1 is also found guilty for the offence under section 13(1)D, read with 13(2) of Prevention of Corruption Act. Accordingly, they were sentenced. Being aggrieved by the same, the accused approached this court by preferring the appeal. Accused number 3 So to have died during the pendency of 3. ಅಲ್ಲೇ ಹಾಕಿ accused number 1 found guilty. Accused number 1 to 5 ಅಲ್ಲ, accused number 1, 2, 4 and 5 are guilty. Since accused number 3 had died during the trial, the case against him stood awaited. ಎಲ್ಲ ಹಾಕಿ ಆಮೇಲೆ accused number 1 to it is stated that accused number 4 has preferred criminal appeal number 811 of 2011. Since he died during the pendency of the appeal, the said appeal came to be dismissed with an order dated 5/6/2025. Thus, accused number 1, 2 and 5 are before this court in these 3 appeals. Orders also. Review the material, point for consideration and answer together. One correct note ಮಾಡ್ಕೊಳ್ಳಿ. Accused number 1 is admittedly the manager of Corporation Bank SR branch Mysore from 1998 to 2000. It is the allegation of the made against the accused that accused number 2 and 5 have mobilized foreign fund from various non-resident Indians NRIs to deposit with the bank. Yet one accepted the deposits from such NRIs mobilized through accused number 2 and 5, conspired with the other accused, forged the documents, used the concocted documents as genuine document, granted loan to accused number 2, 3 and 4. While so granting loan, charge was created on the deposit made by NRIs without any authority. Next part. Mobilizing the foreign currency by accused number 2 and 3, 2 and 5 from NRIs may not constitute an offense. Sanctioning loan to accused number 2, 3, 4 also may not constitute an offense unless it is proved that they are also hand in glove with accused number 1 in criminal conspiracy and forging the documents. But accused number 1 being at helm of affairs as the manager of Corporation Bank is answerable as to how he created charge or lien on the NRI deposits for the purpose of granting loan to accused number 2, 3, 4. Next para. PW13 is the internal enquiry officer who found irregularities, PW13 being the Deputy General Manager, Vigilance Cell of Corporation Bank, held internal enquiry, found irregularities in sanctioning the loan and creating the charge. So he suggested filing of the complaint. Internal enquiry report is as per Exhibit P 173. On the basis of the same PW23, the DGM of Zonal Office, Corporation Bank filed the first information. PW26 is the FSL expert who submitted the handwriting expert report as per Exhibit P86. As per the final opinion, disputed handwriting matches with the specimen handwriting of accused number 1 question mark. Next, PW27 and 33 are the NRI depositors who deposed before the court regarding the deposits made by them and specifically stated that they never instructed accused number 1 to create charge over their deposit. There is absolutely no cross-examination to these witnesses on behalf of accused number 1 to authorize him to create charge over such deposits. When it is shown that the accused number 1 had no authority to create charge over the NRI deposits, he is accountable for the offense alleged against him. Next, accused number 3 and 4, accused number 2, and accused number 2 dash he is the, sorry, accused number 2 and 5 that to have leveraged the foreign currency. What is the role played by them? Next, how the prosecution proved criminal conspiracy against accused number 1, 2, and 5. Yes, tomorrow. ನಾಳೆ ಸಕ್ಕತ್ತಿವಿ